May I please your lordship? Lordship, I beg to mention item number 30, madam, of the illegal list, madam. The up-to-date CD is not available, madam.
CD is not up to date, madam. After vacation,
Up to date, CD was called for.
CD is madam. CD is available, but not up to date, madam.
Are you on it
Yes, madam. Interim may be continued, madam.
After vacation,
after vacation and it
one date, madam. 22.
May I please your lordship? I beg to mention item number 49, lordship. On behalf of M. Ahmed, I am praying lordship. He has some personal inconvenience today. So let me,
position in 49,
For CD available, madam.
CD is available. So when we
any date, lordship.
today
next
he
week.
is not available.
Next week, lordship.
Next week.
Whatever is convenient for this honorable.
Monday or Tuesday or Wednesday, madam. CD be written, madam.
CDP
The interim is there, lordship.
With the lordships,
will be continued next. Important matter.
The,
my lord, with the lordships' kind indulgence, I would like to mention two matters which may come up on Friday.
Which
It's not in the list,
Oh,
Lord.
sir. For 60,
For list.
Friday.
Friday. Of last week.
Declare lordship for listing. Today's date fixed. Today's 53 days lordship, but not listed lordship. Tomorrow lordship.
Date was fixed earlier.
Yes lordship. Tomorrow lordship.
May I please your lordship?
Tomorrow, I cannot say. Tomorrow date is already out. It will be
After list
tomorrow. Yeah,
lordship.
tomorrow. Yeah. Election tomorrow. Otherwise, we have.
May I please your lordship? Item number 38 lordship. May come after vacation lordship.
CD not the same, madam.
Interim is there lordship.
Are you on in meeting?
Interim lordship.
After vacation, anything, CD to remind.
Apply.
May I please your lordship? Regarding item 19, lordship, the POSCO matter, lordship, they advise for the service report, lordship. Item 19, lordship.
Thank you.
Right.
Service report is still available.
No, lordship. The respondent did not appear, lordship, and no report regarding receipt of the notice, lordship.
No.
The LCR has been received, lordship.
Accordingly,
After vacation, lordship, no chance. No.
after we do want a quick date.
Lordship, give the
They said have to again call for the present status
After this,
after this.
because LCR is here, lordship.
Otherwise, LCR is there, but most of it is practical matter. What the progress, so status report may be called for.
Lordship, that may call for.
After this. After this, that
After this, the
ঠিকই আছে এখন আপনার কিছু হচ্ছে
24/7.
much obliged your lord, much obliged.
May please as a lordship. Lordship, I beg to mention item number 56 of supplementary clause list matter.
item number
56 supplementary. Lordship, may kindly take this matter my lord, on Tuesday, next Tuesday or Wednesday, my lord. Next week, my lord, Tuesday or Wednesday, any date.
Otherwise, we receive the scan copy.
Yes, yes, my lord.
Better Wednesday will be.
Wednesday. No,
No. This Wednesday.
26, my lord. I'm deeply offended.
May I please your lordship? My lord, item number 27, my lord. Here, case day was called for, probably it's
not
not
the
this.
same, madam.
Maybe after vacation.
Interim is no?
Interim is,
27.
Madam.
interim is there, ma'am. Yes.
Deeply obliged.
May it please your Lordship. Lordship, I beg to mention for listing of a criminal petition on motion on Friday, Lordship.
Court number.
Actually, Lordship, in this matter, Islamic Senior Counsel PG Sekhi has been engaged and he cannot appear in that. The Honorable Court 21, Lord.
Make a mention there.
Mention there. Then
Listing
it was listed in the
before,
front.
before this court.
Obliged.
May it please, Lordship. Lordship, item number 20 may kindly be taken up in the next week, any day.
Here also we have received the scan copy.
Scan copy is my Lordship.
So that means it will be after vacation.
After vacation, my Lord.
Next week, any day.
No, next week not. Not possible. It will be after vacation.
Fine. Okay. May I please, Lordship? I wish to mention item number 26. CD is not available.
CD is not available. How you? NCD.
Lordship, in this case, charges submitted, Lordship.
If
Which item number you have?
26.
In this case, Lordship, final complaint has been filed, Lordship.
Kindly adjourn for the day.
Yes, has already
Yes, Lordship.
it's already charged. You dispose the matter, just do one thing. You can pray for bail, the court, trial court, before trial court.
Lordship,
You are
it is-
Mr.
M. Hop.
M. Hawk. Hard Mr. M. Hawk. Hard name
M. Dekha
M. Dekha. Danny Council.
for on behalf of SCKL, Standing Council SCKL.
With some body where it has already been charged. Right, yes, yes, number to have.
Lordship 196/2024.
It's number 196
6
2024. Date
12/6/2024.
May I please your Lordship? Lordship, I beg to mention for listing of a criminal petition. The next week,
Make a mention before senior bench, court number
20.
21.
May it please your Lordship, I pay for the listing of an IA for criminal for Friday. Interlocutory.
Number 21, before senior.
Lordship is a special acts.
Yeah. So, understood.
For Friday.
Friday.
Friday, March of next.
Please your Lordship, I beg to mention BA number 580/20 580/24. Kindly matter may be taken up on Friday.
You want to pray for 15?
Yes, Lord. For listing.
Monday.
Friday, kindly,
Let
Lordship.
it on Monday. Friday or both. So better may not be called. Will be listed Monday.
Lordship, it is important matter, so
Important. Everyone is important for Monday will be.
May I please your Lordship? Item number 32, call for CD has not received.
32.
32.
CD not received, my Lord.
Interim may kindly continue.
Are you on interim?
Yes, Lord.
Yes, Sharma, anything?
After vacation, my Lord.
After vacation, it will be on 21st, is it? Or
My Lord.
holiday? 22nd?
22nd, my Lord.
22nd.
22nd.
May I please your Lordship, I beg to mention item number 15, 17 and 25. Lordship, item number 15 kindly adjourn the matter for a day.
15, 50.
15 Lordship.
Yeah, 15 and
Lordship 17, this matter may be listed before appropriate bank Lordship.
15 and 17.
Lordship 17 only.
17 has to be listed before appropriate bank.
Yes, Lordship.
Why? What is the problem?
The coitus bill rejected by the Honorable Justice Malpuri Nandi.
17 is for appropriate bank. And what about 15?
15 kindly adjourn the matter for a day, Lord.
Here, NCB.
Yes, Lordship. And Lordship.
Otherwise, it is a not for bail here.
Yes, Lordship.
Who is the other side?
I have informed them, Lordship. And Lordship, item number 20.
He wants to fix it on 15?
Okay, Lordship.
When?
Next week, Lordship.
You've taken it or 26.
And Lordship.
26.
Okay, Lordship. And Lordship, item
You
number.
inform the other side.
Yes, I have informed them. Lordship, item number 25 allow us 10 days time to file objection. 25.
You're going to file objection or your report will be submitted? What?
Objection, Lordship.
Another that is India was there. Inform
Yes, Lordship.
it, how many 1 week or 2 weeks?
Lordship, 10 days.
10 days. 10 days. 10 days time. And 10 days will be after 15.
Okay, Lordship.
But here the method is a NDPS method.
Yes, sir.
Commercial
Yes, Lordship.
after 15.
Highly obliged.
May I pray, Lord? Lord, I beg to mention item number 11, my Lord.
Yes, 11.
My Lord, there is a slight inconvenience on my part today, my Lord. Can it be taken up on some other day?
Then the irrigation was there.
The irrigation was there today. He is also not there in the court. And my Lord, it will be done by the state only ultimately, my Lord. My Lord.
And it that can come up vacation only. After vacation.
My Lord, the interim orders passed earlier will continue, my Lord. I am deeply preoccupied.
May please, Lordship. I beg to mention item number 39, Lordship. CD is not received, Lordship, so this matter may be adjourned for the day. Please, any other
CD not received, madam. Here in interim, madam.
Are you an
interim order may be continued. So, that may be fixed, Lordship. I love like this.
May I please, Lordship, in item 55 of supplementary list, we have filed an IA for implement. But that is not on record. So, Lordship may fix the matter next week.
you have filed one interim.
No, Lordship, no interim.
No. What you have filed?
We have filed implement IA for implement.
I important.
Yes, Lordship. Lordship may fix the matter next week. Till then, IA will come on record.
You are Mr.
NZ Chaudhary.
What, Mr.?
Lordship, if kindly next week and in the
Today, you have not filed everything.
that is not on record. That is why.
It will be after vacation.
Lordship.
Till 7.
May I please the Lordship? Lordship, I beg to mention listing of a bail application and the PSA. Matter may be fixed on 21st Friday before the appropriate time.
Put appropriate date.
24 is the appropriate. Court number 20.
Appropriate bank, it was dealt by
Bail
other,
application.
earlier it was dealt by other bank.
Yes, sir.
Who?
It was directed to appear before, listed before the appropriate bench, which was 24.
Who? List.
Lordship,
You can approach the bench section in time. There is
Lordship,
approach-
the main accused was granted bail by the court number 24. That's why
So in the case of listing, if suppose matter would have listed today, then we can pass the order that is before the appropriate time, but it's not listed. So how to pass the order that it's before appropriate time? That is not correct. So you can approach the bench section so that the matter will be listed before the appropriate time. Court number
But
20.
the Lordship, it was listed, but due to paucity of time, it could not be taken. It was listed on 14th last.
That one.
May I please, Lordship? Lordship is a 439 bail application. Accused Aman Singh Sinha, who is a 18 years old boy. He was arrested in connection with Patharkandi PS case number 88/2024 under section pilot 354C IPC, read with section 12 and 14 of POCSO Act, and also read with 66E, 67, 67B IT Act. My Lord may peruse the FIR at page 10. My Lord, in the FIR, in the main gist of the FIR is that that boy and victim girl, who is 17 years old, and the accused is 18 years old, they are in consensual love affairs between them, and some video photography was done in a personal relationship, which was made viral. But that Supriya Sinha, victim girl, alleged that he has violated their personal relationship and circulated this personal photograph through Instagram and WhatsApp. That is the main reason. He was arrested, Your Honor, my Lord, 3/4/2024, so already 78 days. And my Lord may peruse the page 11, that is forwarding report. Here, ground of arrest are given, Your Honor. According to ground of arrest given, already that mobile phone has been recovered, and in number 4, independent relevant witnesses is found to whom he has shared the videos. All the investigation already completed, and at the last para, it was mentioned that further requested kindly not to release the accused person at the early stage of the investigation, as he has friend circle in the locality of the victim, and there is likelihood of victim going in trauma. Otherwise, there is no ground for keeping him in custody. He is only 18 years old, and if he is going on there among the
Lordship, here is a POCSO matter is here, my lord. 12 and my lord, Lordship may issue notice at this stage and call for CD, my lord.
Or secretary.
My lord. Ask the concern.
First of all. So I
My lord.
person was arrested on report.
My lord. Report, my lord. And 12 and 14 POCSO is here, my lord. Then
14 is there, but
notice will have to go, my lord.
no. But
Next week, my lord. Next week, my lord. Only 78 days.
Only?
As per calculation, 78 days.
78 days already in custody. My lord, I have another thing. My lord, with due respect, my another submission is there. My lord, this making viral of this photograph is a matter of trial. In this stage of trial, it will be proved whether he has done it or other person has made it. And his age may be considered only 18 years. My lord.
In 18 years, he committed such kind of offense.
My lord,
he will be
both
more mature than he will be a great,
maybe.
It's a criminal.
Maybe, but my lord, according to information,
he has such kind of mentality. Then what about when he will grown up? We are mature.
my lord, according to FIR, they are in
Love relation.
consensus.
Love relation is not this. Love is not.
Both are only 1 year difference.
Whatever. Love is accepted. That is not it. But the act he committed.
According to him, he has not circulated this. One cousin is there who is opposed to this love relationship. He has made somehow higher.
How somehow? Somehow means how somehow?
That will be proved in the during the trial period.
Made by.
Well, then I will have to take instruction mallet, whether any edit section mallet, any section on that mallet. Otherwise, mallet,
That's why I'm giving.
mallet, that is mallet. 12 and 14 mallet.
What is the matter for?
Mallet.
Please.
Mallet.
Mass of
Still listening to.
Milo.
This time. Yes.
Yes, please, Your Lordship. My Lord, the FIR is at page number 16 onwards, my Lord. The case is related to custodial, my Lord, trial. And the two co-accused has already been released on bail, my Lord. And the petitioner is no way connected with the alleged offence, my Lord.
That's the second. So accused is already granted bail.
Yes,
By
my
which
Lord.
court?
My Lord, case number 49 and 49 onwards, my Lord. 49.
Before appropriate bail.
Mallet.
My Lord, the LCR may be called for.
As per notification, it will come to appropriate bench. That is mallet.
Well, then tomorrow, my Lord.
No, that bench is not
My
available.
Lord, there is.
The bench is available.
Not available.
It's for
Appropriate.
May it please, Your Lordship. FIR is page 13, Lordship.
1-3.
1-3, Lordship. This is a long FIR, Lordship. The allegation is that as per information near the house of one Soinal Haq, Lordship, and some other persons, altercation took place with the police, Lordship.
The victim was found in unconscious state.
Mallet. 326, 307 and 353, 332 also mallet. Assaulted the police person also. Also, may call for CD here only.
If you kindly see the vernacular page 18, Lordship, the section has been put in the FIR, Lordship. And it's 18, Lordship.
Yes, registered 147, 148, 145. Here is also that apart the 9 and 4. All these things are there.
Lordship, the petitioners are arrested on 25, Lordship, the annexer to the forwarding report, Lordship.
25-5.
25, Lordship.
Case of 320.
Forwarding report.
May not pay
Lordship, in the forwarding report, Lordship, the section,
Medical report is
the section has been entered in the forwarding report, and subsequently the read is section 13(1) and section 16 of the ACP Act 2021. The earlier incident, Lordship, this is different, Lordship, and the petitioners are attended, Lordship, it is admitted, Lordship, and they are the.
But they all are, these petitioners also arrested in connection with that affair only or other affairs?
That affair, Lordship. The section has been left. This is a long read.
That's what I'm saying. As those sections may not affect this accused petitioner. But for that we have to build because the 326 also.
They are levers, Lordship. They are the only engaged by the final option. The main Lordship, Annexer 2, Lordship. Annexer 3, The main accused has been arrested. Annexure 3, Lordship. Kindly see the Annexure 3, Lordship. Page 22. China law, Lordship. This is the name accused, Lordship. The accused number 1, Lordship. He engaged the present petitioners to carry out the buffaloes, Lordship, from the market to the
Page 14, my lord. Page 14, after their name, my lord. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, my lord. Proceeding back after rescuing after 20 numbers of buffaloes with red cloth wrapped on the horns and mark from the area. Suddenly, the above mentioned accused person along with 150 other people collectively came forward in a group with lathi, zong and sharp weapons and prevented us to perform our duties and caused injuries upon us with lathi, zong and sharp weapons. See, this is necessary.
One home guard was also killed.
My lord, that is sorry. That police person, they have attacked the police person when they were rescued the buffaloes, my lord.
Lordship, that are the name accused, Lordship, is final log and his group, Lordship.
No, all others
prisoners are
they are
the labor, Lordship. Engaged by one Chainul Islam, Lordship. And he has been already arrested.
It can be only find out from the CD, my lord, for their involvement.
Lordship, maybe call for on 28, Lordship. Out of 10 FIR, Lordship, PA number 1648.
It is already picked up
28.
And then 20.
Okay.
Please, Your Lordship. Lordship, unusual prayer, Lordship. I am sorry, Lordship. Lordship, in the morning, item number 25 mentioned by the other side with the consent, Lordship. But matter will fix after vacation, Lordship. Matter will kindly fix on witness. There is a BA matter, Lordship. And the accused petitioner behind the bar around 3 years, Lordship. And earlier, first occasion, Lordship, on 7/6.
Some more time to file their motion objection. Will you be able to file objection by Wednesday?
Lordship, this matter is first
Okay, we will try. But
Wednesday. Okay, then we
Oblige.
নাই দেখা আপুনি খবৰটো ল'ব লাগিব মানে in the last occasion Lordship was pleased to take instruction to us, my lord, whether any case registered against the present petitioner, my lord. We have not received, my lord, any report, my lord, from Dispur, my lord. We will take instruction, my lord, whether any case is lodged against the present petitioner. Original place, no? এখানে তো কিবা এসে যদি dispute भी আছে না day after tomorrow man I don't know man
copy of the day after tomorrow is
my lord 21 my lord
Oblige.
May please. This is a crossing application, Lordship. And the petitioner, who is a child development project officer, Lordship. And the respondent number 2, she was a supervisor. So that time, when he was a district officer, Lordship, then the supervisor, respondent number 2, was entrusted with the government project Ayushman Bharat. In that, he was entrusted to make an entry in respect of the women's ward needy. That time she was absent for 10 days continuously. In that case, Lordship, can look page number first, in lecture 1, page number 22. So she was made so coach by the ADC for unauthorized absence because the progress was very low. And the very next day, Lordship, then the husband of the respondent 2 in the night about 9 p.m. came to the house of this petitioner, who is a district officer that government, and starting quarreling regarding that complaint. Then he, with the discussion of the ADC and the DC, lodged an FIR. The petitioner, yes, the district officer, he lodged an FIR against the husband. I have encouraged page number 23, Lordship. Then thereafter, Your Honor, this lady on 29 come to page number 31, Lordship. Prior to that, Lordship, page number 29 can see. Page number 29, section 3. On 29, page number 29, then 29 March, next day, she lodged an FIR stating that, this is very interesting, that's a below the named accused person is the IC District Social Welfare Officer Dhubri as well as CDPO Goripur IGS project Dharmshala, under whom I have been serving as supervisor. It is to be mentioned that accused person always try to harass me in various ways, both mentally taking advantage of her superiority. I have several times requested accused person not to target and harass me, but did not pay any response to my request that is going to harass me. On being informed to my husband, Dr. Riojul Karim, all about the fact, 28/3/98 at about 9:30 p.m. when my husband went to the residence of the accused person to request him not to harass me anymore, then the accused person misbehaved with me and husband threatened me to take action. So on that ground, she filed FIR. So police did not take action anything over because there is nothing. Then on page number 30, on 11/5/2023, she made a complaint before the Superintendent of Police. And there she stated about the incident of 28/3/2023, wherein he stated regarding that apart, there is nothing allegation of section 354A or 509. Then Lordship, now come to page number 31. Nothing, not a single line, no date, nothing time. Then her statement was recorded under section 164. In 161 statement I have received also that nothing is there, no. In 164 what is said that my name is Rajia Sultan Parveen. I had been appointed as supervisor social department in the year 2016 and thereafter I was appointed supervisor ICDS project Amuni. Suja Burwa has also appointed me in charge. He is senior to me. Since last 3 years he has been starting torturing me. He pulled my hair and clothes. He had called me his room. About 3 years ago, Sujabra had asked me to have sexual relationship with him. When I refused, immediately transferred me to Gwalpara district without reasons. He had threatened me. I have not else anything. No date, time, nothing. In that part, Your Honor, in 160 or in 161 even also, nothing is there. Lordship, regarding the allegation he transferred me, that is not my power. That power belongs to, this is Your Honor, I have received also that. You can see the power bill is of the social welfare. This is Director of Social Welfare of Assam. So this is no 354, Your Honor. I am also producing a judgment of the Supreme Court and our High Court also. Just to harass him. You can see the first part. Victim has not furnished any information in regard to date and time of commission of alleged offence. In my case, in even 161 statement, nothing is there, and I have made categorical statement that no witness has admitted her part to anything that I am furnishing. The 161 statement you have used, nothing is there. No offence has been, nothing has been committed in office. First, the victim has to mention the date and time when the offence, because due to the personal vagueness and even perusing the FIR, 161 statement, 164 statement, nothing is there. Then what happened? What the learned court below has committed mistake. You just come to the page number 34. You comes to page number 34. Unnecessary facing the trial. But the CGM took up the matter, page number 34. Then, while before taking cognizance, below the part, kindly see that. Circular of High Court. Larden Magistrate has to comply with direction of the Honorable High Court in Quebec as reflected in circular dated 25/2015, and the circular is also. But this is the circular copy. This is the 354A and 509. This is circular. But without the next is the order. The magistrate also did not see anything. Whether the ingredients, this is mandatory condition 354 and 507 is there. In the FIR, it has come out. She has mentioned 164 one statements. All the witnesses has come. They have said nothing such as incident, and even her own 164 statement said that 3 years back he did me in that manner. So that is only the offense. So my humble submission, the matter the record we call for in this stage, because unnecessary visit district officer where there is nothing. Even though I can produce the statement of the persons I mentioned in my petition. The office bearer whose statement was recorded, Meghali Ray, Chandrima Chaudhary, they said that মোৰ নাম আৰু ঠিকনা ওপৰত লিখা মতে হয় মই সোশ্যাল ৱেলফেয়াৰ চাকৰি কৰো মই ৰেজিয়া সুলতানক চিনি পাওঁ আমাৰ সূৰ্য বৰুৱা ছাৰে ৰিফিউজাক কোনো ধৰণৰ বেয়া ব্যৱহাৰ কৰা নাই বা বেয়া ইংগিত দিয়া নাই মই দেখা নাই আৰু শুনাও নাই আমাৰ অফিচৰ চাৰিজন ছোৱালী আছে আজিলৈ সূৰ্য বৰুৱা ছাৰে কাৰো লগত বেয়া ব্যৱহাৰ কৰা নাই এডি ছাৰে ৰিফিউজাক শোকজ নোটিছ দিয়াৰ বাবে তেওঁ গোচৰ কৰে বুলি সন্দেহ কৰে then she was suspended that I order have enclosed because long absence without this kindly that
here at this stage Lordship may call for my lord scan copy my lord, and in the meantime notice may be issued my lord. After hearing Lordship may consider
only that stay should be granted because what is the use of 351 nothing is there. Court judgment of our High Court also there.
After getting sufficient material my lord,
no, sufficient
my lord, during the investigation material is found my lord against
that FIR is there. 161 statement I am placing before the court and 164 statement is before the honorable court. Then what else is required? So the procedure should be there. Why the officer who is facing, because now he is posted in Kokrajhar. He is Kokrajhar. Even a record cover, if anything comes out, then we are ready. I brought every record before this honorable court.
Earlier FIR was allowed in 2019.
That's it. That PRC case to be stated that is in 114/2000 before pending before the additional CGM. PRC case 1114/2023. Now it is pending before the additional CGM. Dhubri. This is to be stated.
But again, part of the of the oh, state till next
Date, any date after the case can be fixed because I don't want it to. No, it stays.
it's up to court.
After
Is there?
notice is there.
Yeah, it stays been given.
Notice to not get stay.
It stays. Okay.
Please, the Lordship. Kindly, Madam, will be first of all for timing, Lordship. My senior is on legs, Lordship.
May I believe so? This is a application for quashing the share case, Your Lordship. The annexure 1, case number 12, the share case, Your Lordship. Actually, Pinku Das and I am the husband, Your Lordship. Pinku Das complained against me and my family members, Your Lordship. And this is the case, and only leading in the earlier that, Your Lordship, only attack of some mental and disorder epilepsy against me, Your Lordship. But my Lord, I am a fit girl and I have passed BA also, Your Lordship. After solemnization of this marriage, Your Lordship, after 8 months, he has complained against me, Your Lordship. But my Lord, actual fact of the case is that, Your Lordship, paragraph 5, Your Lordship, case number 6, and actually he is mentally and physically tortured me for demanding dowry, and my Lord, yeah, I have already paid him 40,000 and there, Your Lordship, for 60,000 and a motorcycle and another furniture, Your Lordship. He has torturing me, and in this regard, Your Lordship, I have filed a CRDB case also, my Lord. And the CRDB case has been also been pending before the Munship Kam GMFC Koliapur. And this is my case, Your Lordship, annexure 2, case 16, Your Lordship. Actually, he has complained against me and my family members, Your Lordship. It is totally false and fabricated, Your Lordship. So, my Lord, kindly call for the record and stay the matter. And this case is fixed for tomorrow, Your Lordship, for evidence and cross, Your Lord. Evidence and cross. But this service has been completed, Your Lordship. The challenging share case. And actually, I am the victim party, aggrieved party, Your Lordship. I am totally elaborated about my case, Your Lordship. Paragraph 5, case number 6, Your Lordship. And for my protection, Your Lordship, under section 12 of the Protection of Women and Home Domestic Violence Act, Your Lordship, I have filed a DB case also, CRDB. We have got merit 17/1/2023, Your Lordship, but the share case has been filed on after 8 months, Your Lordship, 1/8/2023, Your Lordship. And in the share case, he has mentioned the name of two persons, Your Lordship, Ganga Das and Shantanu Das, but their name has not been recorded in the share case. Allegation is not.
My Lord, this is the complaint case, my Lord.
Yes,
Let me call for record at this stage, my Lord. Notice be issued, my Lord.
Lord.
They will say, my lord, what will happen, my lord, what is happening, my lord. Respondent, my lord.
Stay may be there also, my lord. I am the wife, your lord. Victimati, and from Nagaon to Dibrugarh, so distance, your lord, long distance. So stay may be there, notes may be. Nagaon to Dibrugarh, your lord. The sale case has been pending before the Dibrugarh, and I am from Nagaon. I am the wife, your lord. No transfer. Transfer matter also.
My lord, that is the new file transfer.
This is the another.
My lord, notice only at this stage, my lord.
Next.
Yes, yes.
In fact, all with the case of
Evidence.
cross evidence.
Evidence.
So, we will
Melody
take step and respond number. Sorry,
it's going. Still,
No. Evidence is.
but Melody, tomorrow is cake for evidence, your lord.
appointment.
Today I am the wife, and my husband has been filed this case, your lord. So, Melody, I am actually main case is I am the victim party, your lord, agree party, your lord. And in this regard, I have filed also CRDB also, your lord. In my jurisdiction, I am
Pending where?
Nagaon, Koliapari, your lord.
We'll check. Yes. Control 8.
Yes.
Your Honor, this is the complaint case was filed by mother against her daughter and son-in-law. Your Honor, the thing is that what is the suppression? The father gave his plot to the builder and 3 flats was given. This is in the Ulowari area. Accordingly, page number 23 Your Honor come up. Also, the suppression was made all along before the every court by the mother. So the builder later on, because 3 flats was given as father expects, so memorandum of understanding was executed with the builder with Medula De, Sujata De Bimal, who is before this honorable court, and Suchandra De. So the 3 flats was accordingly handed over. For 1A flat number that was taken over by the petitioner. So the mother-in-law, later on everything, electricity, everything was done in her name. Mother-in-law filed an FIR on 28th number page before the Paltan Bazar PS under section 294, 325, 506, 34. So police made an investigation, called them. Thereafter they come up from Delhi because both are residing in Delhi and they have 2 minor daughters, about 8 years or 1 year, 10 months daughter. Then they lost this FIR.
Stage of case at present. Is already charged matter or not?
No, complaint case.
Oh, it's a complaint.
Complaint case. So, Your Honor, the thing is that whatever sent they stated.
Inquiry is already.
No, that will come to the complaint petition. That's why I am coming. And what the mistake has been the deposition. I have enclosed. So the files later on police did not take any action. Impugn order.
Yes.
Impugn order is in page number, Your Honor. That is page number 47. There is no ingredients of 294, 441, my own flat, own house, then criminal trespass is there. Our High Court judgment also to bear suspect. No, sir, you know, only submission because from the Delhi, you know, that is very important part. You know, kindly see Honor, why I'm submitting before the kind to page number 50, Honor. Before that, because offense explanation, the video conference has not been permitted. Video conference has not. So how with the minor data they will come up? Honor.
Before you learn it, good.
No, kindly see any sections come up before. These are all available whether any section. Time be good
Before
after.
the High Court, from the High Court that
No, no.
you count video conference.
My lord, today is only on motion, my
No,
lord.
Lord, sir. My only submission, just any date of the vacation kindly be out for that period. If contest is not satisfied, I have no any objection to that part. Because none of the section is applicable. My own flat that is 294 not applicable.
You already affected your own flat.
294 is public place.
These things are happen after that.
No, Lord, sir.
Thereafter.
Only my thing is the only mere submission because both they how they will come
you are going
and face the trial before the landed court.
You have assaulted him.
No, that is kindly see the evidence, the deposition of other witness kindly see maid servant.
I'm not going to say it.
No, Lordship, then only that relief has to be granted for timing part. Only timing part. I'm praying.
After it's not
Any date kindly be fixed, Lordship, after vacation.
25.
Yes.
No stay.
Lordship, that otherwise. That,
May I please, Your Lordship? Okay, matter pertains, page 18 is the FIR, my lord. 9 and 10 are same. Some kettles were seized, Your Lordship, by the police from a particular vehicle, my lord. And page 18 is the FIR. He is the owner of the vehicle that has been seized by the police, my lord.
Is the owner?
He is the owner of the vehicle, my lord. In page, in item 9. So, my lord, ready to appear, my lord. Section will be
28 numbers of
My lord.
captures
Yes,
were there.
yes.
26
numbers.
26
Oh,
numbers.
sorry, 20.
He is the owner of the vehicle, my lord. In item 9.
And that were also there. 26 numbers of live captures.
Yes,
My lord.
And 2 numbers dead.
yes.
Check the vehicle in person and found that the vehicle loaded with 26 numbers of alive cattle, 2 numbers of dead cattle, total 28.
They,
Who is
the way
left to
they took the cattle that out of mostly 28 gold.
my lord, my lord, my lord.
That's why
That, my lord.
So your petitioner was not aware that the cattle were carrying in his vehicle in the second.
My lord, aware, my lord, all the vehicles, my lord, I have got all the documents, your lordship.
No, documents is other part. Why 28 numbers of cattle were, loaded in one truck and all? There was not even a, space also to move cattle. That's why it
Two died.
and that was not better not right. The way you carry. So what is the
My submission is, my lord, when after, my lord, after they died on the vehicle or after that is, my lord, not certain. So my humble submission is at this stage, my lord, I may be protected, I may be record my statement. If anything, my lord, is there, then it is open to your lordship to reject it, my lord. Otherwise, my lord, for the time being protection, let my story be heard. And, my lord, in all the way,
where you dealt with your foot
my lord, page
in para?
my lord, para 6, my lord.
when that one that get over some that seems like subject but was not available for that it as it was not friend but and another person or common no I could it but who but it get cannot say effort but or
After vehicle mile. 25th mile. 25th. Mile.
it prepared after
Mile.
what about 10
10 my lord is the owner of the capital, Tim Kisman.
he is the owner
Owner of the capital. I have got all the receipts, my lord. I have a next, my lord. Kindly see, my lord, para 6. Para 6, my lord.
Same date, my lord.
Obliged.
May I please your lordship? Yes. Lordship, we are agreed by the order of the learned JMFC West Karbi along Hamrin, my lord. Basically, this is a case on 5/6/2024, wherein, my lord, we applied for the Jimma of the vehicle. Well, the vehicles were held in connection with a FIR registered under the IPC and Assam Cattle Prevention Act. The Jimma were granted to us, but subject to the guarantee of the we have to submit market value of the vehicle, my lord. And as such, our case is that, my lord, our vehicle are already on rent. We did not have any idea that the vehicles were connected in the case.
The condition is that is a bank guarantee.
Yes, ma'am.
Bank guarantee was the condition on that you can see.
Yes, ma'am.
But as per Act 55, the 11.5, bank guarantee is the condition.
Madam, I have a judgment.
Okay. So I have seen there are some orders that are good and active, where the conditions were modified or already. I'm not.
There's a coordinate bench judgment on 22.5 which talks about 11.5 is not applicable when a charge has been submitted.
That's why my piece is a bit different. That's why frankly is taking place. You may not get the relief.
No, I have seen the relief.
Can get the car.
We will list it tomorrow, Malak.
Before any other time?
Tomorrow, Malak.
Before any other time? Tomorrow?
Much obliged.
Yes, any other time?
No.
Tomorrow it will be listed. Okay, Chairman. Okay.
This is for washment, and the impugned order Lordship will find is annexure number 5. Here what has happened, Lordship will kindly see, there was a dispute going on between the respondent number 2 and the petitioner. The respondent number 2 happens to be IGP at that point of time at Kokrajhar. And the respondent files an FIR, Lordship will find, in page number 47 to 54. If your Lordship find in page number 47 to 54 the FIR format, the Lordship will find that it is very clearly written down in the FIR that the place of occurrence is 360 kilometers from the police station. So we filed an anticipatory bail before this Honorable Court, and this Honorable Court, Lordship, on wide annexure number 3 was pleased to give us an interim bail and directing that the petitioner should appear before the IO Kokrajhar concerned. Petitioner appears before the IO Kokrajhar concerned, but there he was mishandled. Severely he was mishandled. So he lodged an FIR, another FIR, Lordship will find in page number 61 to 71. The petitioner lodges an FIR at Boshishta PS. Now Boshishta PS finds, Lordship, that the entire incident has happened in Kokrajhar, so Boshishta PS transferred the case to Kokrajhar for investigation. Now Kokrajhar, what the Kokrajhar IO does, Lordship, Kokrajhar IO, he investigates the case, and so far as the FIR filed by the petitioner is concerned, he files a final report, there is a closure report, and in that closure report, he files a complaint under 211. The 211, if your Lordship will kindly see, 211 is a non-cognizable offence, where it is not at all permissible to file a complaint in this manner. I will draw your Lordship's attention to what is there in 211. False charge of offence made with intent to injure. Whoever, with an intent to cause injury to any person, institutes or causes to be instituted any criminal proceeding against that person or falsely charges any person with having committed an offence, knowing that there is no just or a lawful ground for such proceeding or charge against that person, shall be punished with imprisonment of either description for a term which may extend to 2 years or a fine or with both. And if such criminal proceeding be instituted on a false charge of an offence punishable with death, imprisonment for life or imprisonment for 7 years or upward shall be punishable with imprisonment for either description for a term which may extend to 7 years and shall also be liable to fine. Now, if your lordship looks into the classification, it's a non-cognizable offence. The non-cognizable offence, in a non-cognizable offence, 173 cannot be filed. So what he has done, he has filed a closure in form of 173, and there he has clubbed a complaint, which is absolutely impermissible, lordship. That is what I am challenging for quashment. But I feel that respondent number 2 is not present. So let it come after vacation then, lordship, if he is not there. Can it be after 12th of August, lordship? Interim order is still there and it is continuing. And I have also been summoned. Court has taken cognizance under 211. I don't know why the court has not looked into the entire matter into consideration. Maybe because the respondent number 2 holds a very high post out there. Now he is not there, but he is still a very high, in a very high post of a cop. So that might be a reason that the cognizance has been taken. So I would say if this, since the respondent is absent, last occasion also they were absent. They were absent. So anyway, let them be given another chance. I would pray if it can come after 12th of August. But in July, some problem I am facing. I have some personal inconvenience.
It's 12th of August. 12th of August.
After that, or on 12th of August, or after vacation, lordship. After vacation. Diplopus. Interim order may kindly continue.
My lord, here it is the jail
What is
appeal.
going on? Yes, I think.
Jail appeal, my lord. Here, amicus curiae is to be appointed.
Oh.
Jail appeal, my lord.
That's it.
Well,
Not yet.
it is first time it is came to the court.
Yeah. But it's not.
Right.
Out. Mr.
Come.
My lord, before my learned friend starts, I am praying for adjournment, my lord, because my lord, I could not take out my file due to water logging, my lord. So next week, my lord, any date?
My lord, cannot object to that.
I don't know. Date.
If the case study was solved from
No, my lord, before vacation, any day.
Can we 26th, my lord? After vacation,
After.
After vacation.
After vacation, my lord, then can be on the 18th, my lord? 18th, my lord.
My lord, similar prayer with regard to item 45.
Oh. Well, can be some other date, my 18th, my lord.
Okay.
Can be on 23rd, my lord?
Item 45.
Fine. Same problem.
Same problem.
But item 45, we have restricted case diary.
No, ma'am. Case study is not.
Are you going to include it there?
Yes, ma'am. Well, it may be before vacation. Bail and one person, my lord, one person is left.
Next week, the motion matters will be there. So, we're planning this numbers of hearing matter because the Edward hearing matter, you are on interim, so let me after
One person he is not on interim, my lord. Out of 5 persons, my lord, 4 persons they get interim. 1 person.
One is not.
One.
Yes, Mr. Purva. Can it be applied? I think so. Where from it has to come?
It's from Bhopal. Soygaon.
Soygaon?
From Soygaon, Lord.
We can take a test on 27.
I don't remember.
27. Oh. 27. Oh, sorry, no, 27.6. Sorry, 27. 27.6.
Habla.
In this case, I am appearing, but my learned friend, public prosecutor on behalf of the special PT, he has told me that he has another case in court number 14. It's running, so it will be passed over for the time being. Yes.
May I please your lordship? Lordship, this is a subsequent bail application, lordship. The FIR starts at page number 15. Page 15, lordship. Earlier, on earlier occasions also the bail applications have been filed and it was rejected.
Rejected by who? Which bench?
Once Parthiv Jyoti Saikia, Lordship. Order is at
Yes, rejected by.
Justice Parthiv Jyoti Saikia.
Have the next order.
Once by at page number 75, Lordship, Honorable Justice Sushmita Pukan and Lordship, this is sixth bail application, Lordship. Twice by this Honorable Court and 4 times, Lordship, in the lower court.
Let it go before the appropriate benchmark. Who rejected the
last occasion, who rejected the, I mean, you
last occasion, Lordship.
8/1/2024. It was passed or October 75. Is the last order?
Page 75, Lordship. Page 75. Order dated 8/1. This was the last order, Lordship. Before that, Justice Saikia had rejected once. Thereafter, by this Honorable Court.
Our High Court
Page 65, Lordship, order dated 14/8/2023 by Honorable Justice Parthiv Jyoti Saikia. Then, Lordship, at page number 75.
Yes, I have changed it. It is by Justice Count.
Oh.
Okay. Now, the notification was earlier it was not there. But now it's there. So, we have to take it before the appropriate bench. Notification is there that the bench rejected party has to be repeated for the case.
Yes, my lord. Let it be placed before the appropriate.
Or we can keep,
Who rejected the last bail application number?
it's a BA.
BA, Lordship.
He is in custody.
He's in custody, Lordship, since last 1 year.
That's the case, my lord. Then my
Trial
lord,
has also started.
out of my lord, 15 witnesses have already been.
16 witnesses.
16 witnesses examined. Out of 51. Anyway, Lord, let it place before the appropriate bench.
Lordship may observe it, but that appropriate bench, it is sent to one appropriate bench. There is urgency, Lordship. If Lordship, it may be fixed, it is good, Lordship. If it I'm deeply obliged, Lordship.
What about 21? Purva? It's there. But the count perfect.
I filed on the ground of long incarnation. 2 years behind the bar. Prosecution has not yet started. Although 22B2C, I think case record was called for.
For the NCP is appearing, madam. 20,
NCP is appearing.
25. Okay, don't go to the.
Can wait for
Whether it is H1,
Not
madam.
25, not 20.
20. Up to 22.
20.
Yes, yes.
20. Charge sheet has been filed, Lordship. Charge sheet has been filed, charge has been framed under 22B2C. One of the accused is absconding.
But can it be after some time, Lord? My colleague has gone to the LCR.
Let it be at 2 o'clock.
May I please be repeated? Lordship, on the FISM page number 9, the OC Ding PS received some information on 29/3/24 that some people equipped with illegal arms were carrying on extortionist activities at Udandala Chart. And so GD entry white PS, the Ding PS GD number 491, that is 29/3/24 was made. And at 2:50 p.m., a raid was planned. But during the raid, the persons fired 4 rounds in the air and managed to escape. Subsequently, on 31 March 24, an FIR was filed, on the basis of which Ding PS number 48 was registered. Lordship, the facts of the case is that the petitioner, along with Sadiqul Islam, Tahul Amin, and Jiabur Rahman, were plowing around 20 villa of land at Udabdullah Char area. The families have been using this land for the last 20 years. Lordship, the distant cousins of the petitioner, Nurul Amin, Nurul Jaban, Ribul Alam, Rizwan Ahmed, and Rekibul Islam are the cousins by the same ancestors, and they were trying to dispossess the petitioner and Jiabur and their family from the said land. Lordship, they mischievously informed the police that the petitioner and his cousins were carrying on extortionist activities. But in the meantime, they came to the area of the plowing fields and tried to dispossess the petitioners. And they tried to harm them using deadly weapons such as lathi, das, spear, sword, etc. Lordship, in order to protect themselves, Rahul Amin fired some shots in the air and he fled the place, leaving the pistol with Shamim Akhtar. When Shamim Akhtar went to surrender the state pistol to the police station, he was thereby arrested. Lordship, he has been behind custody for around 70 days. Lordship. The investigation has been probably completed by the investigating officer. He may be later on bail.
But it tried on 7 hours. So as per you, he surrendered it via police.
Lordship.
My lord, from his possession, my lord, 1 pistol and 2 rounds of, my lord, ammunition has been recovered, my lord, and seized, my lord. And the allegation is that, my lord, they are...
Was the package pistol?
My lord, it is not clear, my lord, and the pistol has been sent for FSL, my lord, whether it is serviceable or not, my lord. That report is pending, my lord. And, my lord, the material is, as far as the materials are concerned, my lord, they try to, my lord, there are allegations that they are carrying some extortion, my lord, which is illegal arms. This is the allegation, and he is the FIR name accused person. While the police, my lord, went to apprehend them, he fired two shots, my lord, then he fled away. Another accused person fled away, but this person apprehended.
They always get 2 arms or only one? Arm was
only one person apprehended, lordship, and from his possession this arms recovered.
Which arm?
1 pistol and 2 live ammunition, my lord. Other 2 accused person they fled away. And he is the FIR name accused person.
27
No, 90 days.
it was the day.
79 days, my lord. FSL not. And my other accused person, they are yet to apprehend, my lord. They have fled away. Only he has been arrested.
Like it's some construction component from the eye whether they're going. So obviously not, because it's still under investigation.
Yes, my lord, that is why. But other accused person are yet to be arrested. Regarding my extortion lordship, I have not found any material that they were involved in some kind of extortion. But the allegation that is mentioned in the FIR.
Yeah.
Is that
What
it?
about it?
Material from the statement of the witnesses lordship, it is not clear whether
That's what the story is that they were trying to
they were some tractor was also seized from their position So they were doing some kind of
no, as per the petitioner side, there is that they were in their position of that, and the other, the informant side, they tried to possess them.
that is the statement of the that is the statement of the accused person also, But the witnesses, said that, they are, involved in some kind of extortion. But they were arrested from the petty field. That
Not
may be
a case
considered,
that within a very short period, he started to be some.
and he may be directed to cooperate to the investigative.
Mr.
M. Alam.
So, I'm not. I put that. So one was there, na? One with arm. That's for you.
Yes, ma'am.
Where you have it's for the jurisdiction of Nagaon or
Lucknow.
it is under Green case.
SDGM Bhimapur. SDGM Bhimapur.
SDGM?
मतलब SDGM Nagaon.
Please, Your Lordship. Extremely sorry, Lordship. Item number 21, I was on legs on another.
It is passed over, my lord.
It is available. Can it be had on?
We have already fixed it on 10%. Okay. Because CD was there.
May I please, my lord? On instruction, my lord, I am going to withdraw this petition, my lord.
Your Mr. H.
Yes, my lord.
Without a according to the
Apply.
Should my here kindly peruse the FIR in page number 17. The present petitioner Lordship was the helper and he is languishing since 17/9/22. He was arrested more than 2 years he is there, Lordship. And Lordship will also find that here it is written down that the authority letter was sent through mobile, WhatsApp. The vehicle was seized and the driver, Pankaj Sharma, and helper, Manish Kumar, was arrested from there itself. Charge has been already framed under 22B2C. No witness till today has turned out Lordship. The Lordship looks into annexure number 5. Lordship will find accused Pankaj Kumar and Manish Kumar are produced from the jail through video conferencing. In the petition filed by the petitioner Satish Kumar seeking bail for the accused person normally named so. Here considering the method on record, the gravity, it was rejected. The accused persons are remanded back from 14/11/2023. Jima petition is represented by Sunday. This is not important. Now, the Lordship will find that no in view of the aforesaid, in light of the submission made, the aforesaid seized vehicle bearing number so is given in the interim custody to the registered owner. The vehicle has also been released after his personal appearance, subject to the condition that the registered owner shall execute parenthesis. And they are languishing in jail. No development till today. Only on basis of long incarnation, Lordship. I am praying that there may be Manish Kumar, for Manish Kumar only. Manish Kumar may be allowed to go on bail on any condition deemed fit and proper, because witnesses are not running out. Since the charge sheet has been filed, investigation has also complete. There is nothing more to investigate it, and there is detention will be only a formal detention, nothing more than that. And therefore, on any condition, he may be allowed to go on bail, Lordship. He is suffering from some illness also, that I have been intimated. Some ear problem he is having. I think my brother will have the case report.
LCR is there, madam. Here, madam, total 8 witnesses are to be examined, madam. And the charges were framed But my lord, the problem is that my lord, one person is known as absconder, my lord. So my lord, for that reason, my lord, the next date is fixed for the production of the absconder accused. NBWA has been issued against him. My lord.
He's not how witness serving.
No, my lord.
No,
Is a
no.
product not yet examined, but because of the that one person is absconding, my lord.
Sir,
So
how-
at least,
how-
my lord, they can make a prayer for splitting the trial, my lord.
How police can show absconder? Okay. I am there till 2 years. That can be considered. Lord. I was arrested. Lordship will kindly see my forwarding. I have 14 to 19 is the FIR. Lordship, on the same day itself I was arrested. 14, 12, 9.
14, 12.
12/9/22 is the FIR. my lord.
Same day I was arrested. Lordship. There was a Naka. In the Naka, the vehicle was coming from Tripura and in the Naka checking. And Lordship may kindly see nothing has been seized from my conspicuous position because I am a helper, only a helper, a 20 years old boy, a very small boy. I am praying for him only for Manish Kumar and for nobody else. Only on the ground of long incarnation, Lord. I am not at all on merit now. Because we do not know what is the merit of the case, the prosecution has not been able to bring a single witness. And how police can show an absconder?
I have explained that why trial has not proceeded, and he cannot say there is no contest position because he was there in the vehicle, my lord. The law doesn't say that if you were there, my lord, you cannot say that. It was, my lord, very strange, it was concealed.
In a secret chamber.
Secretly, my lord. So
Chamber. So whether that secret chamber
every
was.
intention is there to transport this.
How can my brother say so? Whether the secret chamber was prepared by me? Where is my statement that the secret chamber was prepared by me? They have given the vehicle to Jimma to the owner. Maybe the owner has prepared the secret chamber. We do not know.
I will give that will come out in the trial, man. Now, but they could, what they could do better, they at least within this one and a half years, man, they have not paid for anything for splitting up of trial or after trial for proceeding of the. They are simply sitting, well, whether they have made any prayer, man. No, man. Because the other absconder, my other accused is absconded by NBW.
They are simply sitting means lordship. They have no idea regarding any legal implicacy. And my instruction goes that they are not having any local lawyer also. And just now I have been instructed that the owner himself is an absconder. He has been shown as an accused in the supplementary charge sheet. Correct? In the supplementary charge sheet he has been shown an accused. And Jimma has been given to him. Jimma has been given to him and now he is absconding with the vehicle and I am languishing in jail for last 2 years. If my brother has any objection, then let it come after vacation, Lord. Let us see within this time if something happens. Some witness comes out, turns out or not.
He wants to do after vacation, that is okay, my lord. But that has to be the main part, my lord. So they can make a prayer there or.
Well, I will advise them because they don't have any local lawyer. That's what I have been told.
My lord, in this way, because otherwise one accused is my lord absconding and he is from my lord Pune. From my lord.
I am not from Pune.
Other accused.
Other accused. So your lordship will kindly see that I will have to advise them, lordship, because they are not having any local counsel out there.
This petitioner, my lord.
He is from Bihar.
He is from Patna, Bihar.
He is from Bihar. I am admitting to that. I have disclosed. Okay. Let us see if any development is there.
No.
Lordship, may kindly call from a report from the jail regarding the health condition of Manish Kumar. I have been told that he is having some problems in his ears and maybe some.
Lordship can also call for a report from the, if any progress report.
Progress report also.
here from.
And also, my lord, the progress report.
Progress report also,
regarding
Lordship,
the
may kindly
trial.
call for. On the code below.
If we get it,
As per the convenient of this honorable court.
18, 50 or
18.
18.
Deep blue, Lordship.
Okay, my lord, this is a 438 application, my lord. Saibur Rahman, my lord, all the documents we have submitted, my lord, file and affidavit also with the identity card, etc. 20, not mine.
Non-appeals,
28, 28, we have
the
case
city is
date
also not received, my lord, 28.
and
After,
RD, it is
yes, yes, sir.
entry was there.
Yes, sir. Last week of July.
According to after big
Lordship.
after big 29,
Yes. We have to give a, my lord, date for calling the city that is during
29.
Please, your lord, it's a 438 application, my lord. There is a mistake of identity, my lord. That's why court wanted to ask me to file an affidavit, what is my actual name, with all documentary evidence, Aadhaar card, etc.
You have already filed?
Yes, I have already filed in the record, my lord. And I have given the copy also to my learned friend. Now, my lord, the main culprit has been arrested, has been enlarged on bail. It is the allegation is that some skin of the animals, all animals, my lord, were found in the house of the culprit, actual culprit, my lord, who has been arrested, Saifur Rahman, Safiur Rahman, my lord. And I am, my lord, Sahibur Rahman. Father name is also different, my lord.
So you are Sahib.
Yes, Sahib.
And the actual culprit name of
He has been arrested, my lord. He is Safiur Rahman.
Huh?
Safiur. Father's name is also different.
Was there any other
Lordship, from the record, I do not see any cause of action yet, such because the petitioner has neither received any notice, and otherwise, Lordship, in the complaint there is
so why
nothing.
you have why do you have
My lord, police is coming. I cannot stay at home. Police is coming. You come to the police station. That's why I am ready to go. Kindly give me some protection.
not there as per the
Yes, let there be an observation that I am not required. I am ready to appeal. Then I can fight with the police.
This order can be used to, Lordship, used for other proceedings.
No.
Because
I am
do
very
not
much
see any
honestly
cause of action.
submitting bona fide. I have nothing, no other intention. Just to protect myself, my civil liberty.
How can you say there's no cause of action for the particular the person?
Because there is no notice to appear, nothing in the petition. It is about somebody else.
Notice may not be there, but
Lordship.
as per their
Yes.
of the client,
Lordship.
police is most probably searching him.
Lord.
That with that apprehension of arrest, they file one. But in regards to identity, most probably he is not the person as per them. I don't know. Also, if you want any clarification from the petitioner.
Lordship, some clarity may be required, or Lordship, some liberty may be given to the department. Otherwise, there is nothing.
My lord, petition is pending since long. Well, as 9/9/24. No, I'm sorry.
It is pending since February, my lord.
Lordship may impose some conditions that if
Yes, I am
this
ready to apply.
interrogation is required, he may appear before the investigating officer. Otherwise, Lordship, I also, Lordship, don't see any adverse materials against, at least in the petition, Lordship. There's nothing on the complaint also about. And this person, this other person, Lordship, he has
been arrested and enlarged.
already arrested, Safiur Rahman. So it is not a case of mistaken identity, Lordship, because this is a different person already arrested. Here it is an anticipatory bail of a person not even sent a notice or anything like that. So no case of mistaken identity, Lordship.
I am ready to appear and statement also. Thank you, but
order because otherwise
my lord, your lordship can. My learned friend is saying that he is not wanted, not required, nothing is against him. So, my lord, you can dispose it on that line also. But otherwise, I am ready to appear and give my statement that I am not this anyway connected. I am not this person. Also.
they will get report from the
Lord, we have. CD was Lordship submitted.
Otherwise, only the name of only one Safiur Rahman is there.
Yes, he has been
already
arrested.
arrested
And recovery from his house also, recovery, some scheme.
But I don't see why the petitioner here is coming.
My lord, nobody, at the hand of police, nobody is safe. That's why, my lord, police is coming. I want some safeness.
A special PP wildlife. Digogoi.
Not the accused, so you named it already accused.
Yes, but police asking you come to the police station.
Person or transport. Yes. One. 5. But the that speaking and debating that that what so so what for what cooperate? What kind of cooperation with?
I'll whatever requirement. If they ask me to go, I'll do cooperate if necessary. If I am arrested or I am released on bail, I'll cooperate with the investigation.
No, release on bail for what? For what? Which case?
Well, I am
No
absolutely
cases, no case against.
Your Lordship made an objection that no cases against him.
Lordship, that would be an observation on merits of a future case, Lordship. That might hamper some. I don't know, Lordship. What
That's
is
why
the
I am praying
apprehension
for pre-arrest bail, my lord. Give me protection, matter will end there.
Privilege of pre-arrest bail is how on what basis? So what have made the observation against him? There is no further nothing is there. That
But yes, if your Lordship incorporate the submission of my learned friend that
yes. And subsequently, the submission made by the council that what they have get the no cause of execution and 41 is also not served.
and he is not required of.
May not be required, but I don't know if it's subsequently it is required and all. But at present, from the above all the circumstances, the office is not required. It's not a taken of identity also because superiority is already at. So that also may have to.
But it is disposed, I think.
Yes, it is.
I think 6. And this is a 482 application I have come before Lordship. Well, I take the Lordship page 13, kindly. In the year 2013, I being the wife was granted maintenance of rupees 4,000, 3,000 and 1,000 for my child, my lord. Total 4,000. So I am getting it regularly. Now my lord pays, he has filed my husband has come to the court and at Dhemaji and filed a miss case number 5 of 24 with the prayer that since I take your page 19, kindly it is his application. Madam. The petition is the second party 2012-13 in miss case number 4413. Additional Chief Judicial Magistrate Dhemaji awarded 3,000 in favor of the first party Rukmini Malik and monthly maintenance of 1,000 in favor of the child first party maintenance. Be it mentioned here that 12-13, though Honorable Court ordered in favor of the first party, at the time the first party was a government employee, that is this petitioner, husband, he was a government employee. It is about after 20 years, he has been serving at a present also, first party is also in service. He said that I am in service. First party being government employee, taking shelter and falsehood and mislead this court, Honorable Court, in a wrong way. The documents connection of first party exhibited herein, Exhibit a letter dated 30/1/24 addressed to SP Dhemaji. Exhibit B, letter dated before the account and SP, Office of the Additional SP Crime, PIU letter number such and such. Exhibit C, receipt of first party. Exhibit D, letter received by the SP Gogamukh. Second party earlier, remember my second party that I am the second party, now I am second party here, wife, a sweeper at Gogamukh PSC. And on 30/11/23, she left the job. I have left the job. And release order is annexed by him. After release from the job, the petitioner did not get any money from his department. Presently, the petitioner's health condition is not good. At present, the petitioner's husband is not in a position to treat for his own treatment, even not in a position to purchase essential items. At present, the petitioner's husband has no to maintain additional expenditure of his children, and the name of the one son is Bishwajit Malik. He is studying at B Pharma, and another child name is Bijay Malik, who passed higher secondary school in 21, but due to the financial problem, he could not give admission to further studies. All this thing he is admitting the condition of his own children. That is from my wife. Considering the financial condition of the petitioner's husband, the order passed by the Honorable Court in connection with the maintenance of wife to the second party is not in a position to maintain the wife first party. The wife first party is government employee, for which second party is not bound to pay maintenance to the first party. It is therefore prayed that second party husband may be exempted for payment of maintenance. So he has filed this petition, my lord. Therefore, he may be exempted from payment of maintenance, my lord. Now, my lord, landed court has page 27. First party is present, second party SR not yet returned, issue notice. Court has taken cognizance and issue notice, my lord, to me. Now, my lord, my only prayer is that he is saying that I am serving, I am nowhere serving. I was working for as a sweeper, my lord, for some time I go for cleaning this office, etc. They engage me for 1 day or 2 days, my lord, some 200, 300. But I am not in a regular job anywhere. Then, my lord, I take your lordship, page 35, kindly see. Today is fixed for hearing of the petition. Heard the learned counsel for the petitioner. She has submitted that by mistake the petitioner of this case, who should have been first party, has made me in with second party. Anyway, it is a mistake. Opposite party, who should have been second party, has been made first party. Therefore, she has prayed for the amendment of the petition. She has further submitted that there is no need to amend the assets and liabilities which is submitted on the last date, which is 15/5/24. Therefore, the same is accepted. Learned counsel for the opposite party filed the petition but did not appear when called for. As such, the petition number such and such, the petition has taken either supported by any medical document and no submitted has been given. Whereas the case record, it is revealed that the written statement of the opposite party has not yet submitted, and as such, the interest of justice petition is allowed 24 for amendment of the petition. I have come, my lord, against this, my lord. After 2013, award has been given. Now he is saying that he is a retired man. Now he is sick, he cannot maintain the wife, and he said also that his son, through him, my lord, one is higher scientist student and one is studying B Pharma. So, my lord, that 1,000 may go because children has grown up, has become major. That 1,000 may go. But 3,000 that remain, that have to be remained. Now, my lord, my prayer is that my prayer is that my lord, at least notice may be issued to the husband, my lord.
Which order you against which order you have come?
Now, my lord, court has taken cognizance of this matter.
No order is there. Court is taking cognizance of the case of 127 1CRPC.
No, my lord, this case ought to have been filed in the original case of miscase number 44/2003-13. But instead of that, new case has been initiated. That is a miscase number.
Maybe it is a miscase, it is registered as a miscase, but it is a 127
Exactly 127.
like 517. Now see what is the order passed by the Gallant Board. This petition may consider penalty because at present your as far as your petition has already left job.
Yes.
She was in the job as far. So whether that has there by that petition we claim for any recovery. He's not claiming.
No, he is not claiming, my lord. Husband has said that he cannot pay. Husband has come. I cannot pay any money.
That's what husband comes not and the sons are already grown up, so they are not.
Children has been grown up, my lord. That's right. But a wife, 3,000 will. I think that cannot be changed.
3,000.
Yeah.
So they paid for outreach or whatever under 127.
Yes,
Order is not there.
he can come.
He can come, but order is not there now.
The order is not bad, but notice has been issued to me. That's why I have come before it.
How this notification? The court will hear you because that's why WS you are allowed to get WS also.
Yes, but the question is that now new case have been registered.
It's a miscase. It's okay, miscase is it. It will be tagged with the original only. Or you can make a prayer that it may be tagged with the original only because it's a miscase one time.
Well, your lordship, that's why I want that it should come up with the first.
Notice, but it's a case of a premature one, I think, because it's no order is there. Under 127, no order was.
No order has been passed. Only notice has been given, my lord. So my only prayer view is that let this matter be tagged to the original case instead of new case.
You can file it that original case will be taken.
Your lordship, I dispose it with the direction that I will pray for new, that it should be tagged with the original case, 2013.
That is your main difference. That is separate, registered separate.
Now new case has come. New case. Under 127, new case number is the miscase number is new.
That is one. That is
5 of 24. 5 of 24. Original case is, my lord, 44 of 2013. He have to file a petition in that case.
Yes, if it is supposed registered as a miscase also, nowadays it is miscase on the basis of any petition, miscase may be registered. I don't know what is the process. But the question is that obviously it is the offshoot or whatever you can.
Offshoot, no doubt.
That is it. So you want any direction or what?
Your lordship will dispose with the direction.
So is there any prayer for that purpose also that they should be?
Yes, ma'am. Our prayer is that, ma'am.
Where is the prayer?
Prayer is. Prayer is the opposite party to show cause as to why the proceeding under 127 1 CRPC being miscase number such and such pending in the court of the line of judicial minister first case Damaji shall not be set aside and quashed after perusal of the record cause or causes being shown, and if the hearing the parties be pleased to set aside the quashed the entire proceeding 121 CRPC being miscase number 5 of 24 pending in the court of the line of judicial minister first case.
Okay, we'll dispose the matter. Give a direction.
Obliged.
It disposed of. It is.
Give
Okay.
May it please your lordship. Lordship, this is a 438 bail application, lordship. What happened in this case, lordship? We have filed.
Yes.
Lordship, kindly pass over the matter for timing.
Lordship, what happened? May I, lordship, pray, lordship, the LCR is there, lordship. The charge sheet has submitted, but no charge sheet has submitted against this petitioner, lordship. That's why, lordship, I am given a flag marking.
Lordship, this is anticipatory bail, lordship.
That,
this
lordship.
Investigation is going on, lordship. He is the receiver of the contraband, lordship.
Lordship, may I take your lordship flag mark?
Are Earlier we have submitted one report, Lordship. That is in the record or not? I couldn't check, Lordship.
That the record has come. The report
Yes.
separately reported there. Any separate report there?
Lordship, we have submitted one report earlier, Lordship. That is in the
So can you take that
Lordship, I have a
procedure is up or it gets up?
Lordship, some other day, Lordship. Today he won't come, Lordship. He is on lecture court number 1.
Also matters also. So now this is that AB.
AB,
And
Lord.
he is subject that it's not a considered case.
Yes, Lord.
But as per you, probably there it is still
Going on it.
the probability may be there. So what to do? Can it be heard tomorrow or tomorrow also possible? I don't tomorrow list is already there. At this Monday. Monday.
Tuesday, can it be on Tuesday, Lord? Can it be on Tuesday? Tuesday or Thursday, any day. Wednesday.
Friday,
Or Wednesday, then Wednesday, Lord. Next Wednesday. Lordship, I had that, Lordship, can you peruse that, Lordship, order on pass on 29 1 24, Lordship. There's-
29-1.
Yes, Lordship, then the LCR, Lordship. I have given the flag mark, Lordship, there in the LCR. Can you see, Lordship? Lordship, I have filed this anticipatory bail, Lordship, prior to filing of the charge sheet, Lordship. There is a notice issued to this petition under 67C, Lordship. That was the defaulter, Lordship. That time he was asked to appear before the IO, Lordship. Subsequently, they have filed this charge sheet, Lordship. In charge sheet, Lordship, prime accuse has been, yes, Lordship. I am not, Lordship, no charge sheet has been framed, no charge has been framed against me, Lordship.
Yes, you are not certified. That's fact. So it is not disputed.
But now,
But the question is that they are saying that investigation is still going.
after completion of the charge sheet, Lordship, whether there is any prayer for, Lordship, additional,
We let them. So Tuesday we are fixing.
Tuesday.
Wait.
I love it.
May I please, Your Lordship? The engaged counsel is out of session, Your Lordship. For the time being, 1 week time may be granted, Your Honor.
Interim?
No
Anyone
intent.
is no, not.
No intent.
We have received the case.
Yes, received my some technical difficulty is there in this case, my lord. But my engaged counsel is not here, my lord. Because your lordship, because the CD may not be, my lord, relevant to this case, my lord. Because my lord, lordship may kindly see the prayer, my lord. Because lord,
Yeah, prayer.
in my lord, page 8 in the petition, my lord. The petition, lordship would see, my lord.
Yes.
The prayer, my lord. It is therefore prayed a lawsuit to be pleased to admit this petition call for the case because notice to opposite party to suppose that the petitioner shall not be granted 3 years bail in connection with complaint case number such and such. One complaint case that has been annexed, my lord. This complaint case has been, my lord, filed by the petitioner, my lord. That has been annexed here.
Filed by the petitioner.
Petitioner, my lord.
Which
Another,
is annexed.
yes, that has been annexed, my lord. Page 18, my lord.
This is filed by the petitioner himself.
Yes, sir. So let's look at here. And this
The
read, my
petitioner,
lord,
name of the present petitioner
is my lord Anisul. Ani.
as per this petition, three petitioners
Yes,
are
three
here.
petitioners, my lord.
Samsul,
Sahidul, Nazatul.
Nazatul.
Yes, my lord. This is filed by Sahidul. My lord.
That complete.
Yes, sir. Page 26. Regarding my TR case number 144.
They have annex 20.
No, my lord, two, my lord. Annexure 2, 3 and 4.
Annexure 2 is here 20 to 24.
Annexure, my lord, 3 is, my lord, here case number 144. And Annexure 4, here case number, Annexure 2, here case number 220.
Annexure 2 is here case 220 then.
And Annexure 1, here case 144.
Annexure 1.
140.
144.
No.
And 144 is also filed by the petitioner.
Yes. Complaint. Let the council come. Well, next week, my
1
lord,
week time may be granted, Your Honor. 1 week time may be granted, Your Honor.
See, 1 week will be a problematic because next week motor method will be there. Okay,
Much obliged, Your Honor.
Because it might be, my lord, the complaint case may be registered in FIR
so you
also.
have received the thing for against which case?
This is Lala PS 84/24.
Or
Right.
those complaint case will filed by petitioner.
Yes, but one is by, my lord, Dilwara Begum, my lord. But this is before the CGM Haila Kandiba. So perhaps this was ordered for registering as an FIR. That might be it. So,
Much obliged, Your Honor.
there will be technically
yeah.
but repeat.
I will also peruse my lord.
Much obliged.
Okay.
Get it.
May I please, my lord? My lord, petitioner before your lordship has been in detention since, my lord, 36/20/22, my lord. 30/06/2022, my lord. What happened in this case, my lord? On 11/6/2022, a minor, my lord, met with the petitioner committed suicide in his house. After her death, my lord, the petitioner reported the same to the Bipori police station, and an UD case was registered on the same day. Thereafter, my lord, she was brought to the hospital. Postmortem was done. Postmortem confirmed in the first post in the that my lord, it is a matter of suicide. So that was closed. My lord, and some SFL, my lord, some articles were collected. Those were sent for, my lord, given to the police for FSL, and later it was sent for FSL. But the father of the, my lord, the deceased girl, minor girl, he came on the same day to the hospital, but on the next day, due to investigation of some people that it is a murder, not a suicide, so he filed an FIR the next day. Next day, the case is registered on 12/6/2022. The Normal Dhola PS case is registered. Now, while registering after registration of the normal case, my lord, under section 302 POCSO, my lord, some sections are there. The petitioner later on surrendered himself on 36, my lord, 2022. And since then, he is in detention. In the meantime, 36/2022, he is in detention. And while he was in detention, first search sheet was filed. Search sheet filed on 25/09/2022. That was searched. That was filed before 90 days, just before 90 days of the some surrender application. Then, my lord, some more accused, those, my lord, there are some subsequent stories, my lord. After 74 days of the, my lord, the death of the minor child, my lord, that girl, and post-mortem was, first post-mortem was done. The dead body was exhumed, and second post-mortem was done after 74 days of the, my lord, post-mortem, first post-mortem. And in the meantime, my lord, so there were allegations that the doctors, my lord, they did not do they have due to, my lord, they have taken some bribe, so they did the first post-mortem report, my lord, illegally, and those allegations are there, and there is allegations against the, my lord, the magistrate who committed that he has not done his work properly. Then the, my lord, the second search sheet was filed against them on, my lord,
against the doctor.
Yeah, doctors and the, my lord, the magistrate. So supplementary search sheet in the same case, my lord. It was in the same case. Supplementary search sheet was filed on 03/02/2023. So the first search sheet was filed on 25/9/2022, well before the 90 days. Second search sheet was filed on the supplementary search sheet was filed on 03/02/2023. Now, a brief story is there, my lord, in the search sheet. I have annexed the search sheet at page 47. Page 47 of the, my lord. That is the search sheet, part of the search sheet, my lord. 16.1, the brief, that is the brief story, my lord. Whatever I have stated, that was the story. Now, the search sheet, my lord, thereafter, my lord, I approached the Honorable Learned Court below. The court below has rejected my bail application, my lord. That is, I have annexed. Mainly on the ground that it is gravity of offence, my lord. The Learned Court below has not considered other aspects of the matter. Yes, my lord, considered the gravity of offence, as the gravity of offence, the offence is in grievous nature, so the bail was not considered. Now, my lord, my submission is that, my lord, yes, my lord, as search sheet has been filed, we have to look at least the prima facie, my lord, what is prima facie there in the search sheet. The search sheet is, my lord, the entire case. It is admitted then position that the girl is, my lord, found dead, whether it is committed or murdered, that is to be found in the, my lord, trial. And whether indeed there is sexual assault or whether there is or not, this has to be found out in the trial. Now, only, my lord, the basis of search sheet of the prosecution is, my lord, the technical and medical, my lord, evidence which were collected by the, my lord, prosecution and which has already been recorded. My lord, the basis is the second post-mortem report. First basis is second post-mortem report, which was done after 74 days of the, well, the death of the deceased. But in the second post-mortem report itself, the doctors, the experts who were there in the second post-mortem, they have admitted that on the basis of the first post-mortem report and, well, documents and photographs given to them, they have come to conclusion that it cannot be a murder. It cannot be suicide. It may be a murder. But it is suggested, in the report itself, it is suggested that it should be corroborated by, circumstantial evidence. That is, strictly I am going to the second post-mortem report, my lord. First post-mortem report is clear, my lord. There is nothing. First post-mortem has said that there is nothing. It is a suicide. And the second post-mortem, your lords will find 107 is the finding. 107. Yes, 107 of my petition, my lord. Based on the, my lord, your lords will find, have your lordship confirmed. Based on the first autopsy report, so they have also based the first autopsy report. But the prosecution has, my lord, totally given goodbye to the first autopsy report. They are relying on the second autopsy report only, and they are confining the person, filing the search sheet. Based on the first autopsy report, the second postmortem report also based on that, my lord. Based on the first autopsy report and the findings of the second autopsy report, death was due to compression of the neck during life. She was also subjected to physical assault before her death. However, this part, my lord, the investigation officer is requested to corroborate the autopsy finding to the circumstantial evidence. So whatever is there, that has to be corroborated by, my lord, circumstantial evidence. Now, in the entire case, the prosecution has taken, my lord, near about 70 to 60, more than 60, 70 my lord, witnesses. There is not a single witness who has seen the actual occurrence. There is only one person who has seen the occurrence after the incident is occurred. My lord, he is the first person who has seen the occurrence. If your lordship, I am not troubling other aspects, my lord. If your lordship, probably the record is there, my lord. Just I want to read out the, my lord, the evidence of, my lord, the so-called eyewitness. Apart from that, there is no eyewitness. The search sheet is, I am surprised how it is, the search sheet is prepared. The paginations are not correct. All, my lord, mismatch. In fact, whatever copy supplied to me, your lordship will find, if it is, my lord, page 87 of the search sheet. Probably this is not page 87. Your lordship may find page, this is page 29. So, after page 31, page 32 is the, my lord. If it is the search sheet. Yes, ma'am.
Next item, item number 34, my lord. That matter, I may be allowed to withdraw that.
34. You want to withdraw?
Yes. Yes.
As per the instructions of your
Yes.
order withdraw. 34. Okay, it is disposed on withdraw.
All right.
Mr. Pike, who is taking now the FT matter?
FT matters today, my lord, Honorable Justice Suman Syam and A.D. Chaudhary. Otherwise, the bench number 3 is there. Bench code 3 is taking up. Code.
Rashida. Lordship.
It's number 24 of the 24, the date 31/5. 24 of the 20, the date 31/5.
Lordship, may kindly protect me till my appearance is. No, Lordship. And furthermore, Lordship, one more thing has to be seen, whether my name is in the charge sheet or not. That information, I think my learned public prosecutor does not have. So, Lordship, may kindly fix it day after tomorrow. Yes. Lordship, that is why Lordship may fix it day after tomorrow.
Your name is not there. No, then it's okay.
Lordship. How nice.
My lord, I was showing the
Evidence of
yes evidence, my lord, the statement of the sole eyewitness who witnessed the, my lord, the evidence, who witnessed the occurrence, my lord, closely, my lord. That is in, my lord, piece 16.
1/6.
Yes, my lord, piece 16 of the search sheet. in the record, my lord. But it is so mismatched in the definitions as well as the records, my lord. I'm actually not clear. But this is no case diary number. Have you lordship
You
put
are
it?
on the statement of the eyewitness.
Yes,
His
my lord.
name is?
Asghar Ali, my lord. Only, he is the only eyewitness, Asghar Ali.
Have you flag marked it one?
No, probably it is not, my lord. If I may get it, my learned friend.
On Asghar Ali, I can just pass on the statement of Asghar Ali, which I have. It will be, otherwise
Yes,
they have
yes,
to file a
number-
compilation.
Three statements at home.
Otherwise they have to file a
Have you
compilation.
annexed all those statements? No. In your
My lord,
petition?
this is part of the search segment.
No, part of it.
Yes.
No, part of the search segment. Have you annexed here?
No. It is not annexed. The statements are not annexed.
Compilation of the statements will be required for
statements of the compilation is required.
The statements that they want to rely upon and the documents they want to rely upon. If they file a compilation, then it will be easier for adjudication process. Otherwise, going to the materials, the scan copy, and it will be difficult. I think your lordship will find a little bit difficult. So let them file a compilation of the statements as well as the documents which they want to rely upon. On that basis, I will submit a statement.
The records were called for quoted purpose only.
Last that one, order was passed for appointment of an amicus also.
Amicus has been appointed. ma'am.
Appointed.
Yes. Amicus is appointed.
Who?
Some deep.
One P Das.
Means? Pida. Pida.
For your lordship, may kindly go to that. Just I'm showing it. That's in my compilation.
This is the assault statement to 18/8/2020. This is the 18/8/2022 statement.
Yes, she is statement, my lord.
Yep.
If I read out the statement for his convenience, as he is projecting the case that he is the sole eyewitness in this case who had seen the hanging victim girl in the hanging position. If your lordship permits, then I can read out.
I have that. I can read out. So may I read out slowly, my lord? First, my lord, there are three statements of the eyewitness. That's why I am relying this, because
I'm just asking you whether you have annexed here. No.
No, my lord, it is not annexed. It is in record, my lord. My lord, on 11/6/2022, the incident was occurred on 11/6/2022. On very that day itself, police one Kuldeep Pukai, who is the SI of my lord, Sub Inspector of Police, he recorded a statement on 11/6/2022. That is statement I am reading out, my lord. My name is available cited above is true. I am milkman. He was milkman. I need to deliver milk. I went to deliver milk to Krishna Kamal Borua. He is the accused, my lord. House where the occurrence took place. The Krishna Kamal Borua, who resides at the Dhula Bazar. As was today, when today I came to deliver milk. As usual today, I came to deliver milk at his room. After ringing the doorbell, Krishna Kamal Borua screamed for help from inside the room. When I went to the room, I saw Krishna Kamal Borua was holding their maid girl hanged from the ceiling fan. He asked me to help. He asked my help to unhang her, but I refused to help him. Krishna Kamal Borua brought the girl down and kept on the veranda. That is his first statement on the first day, on the very first day. Then he has given another statement, my lord. Why I am showing this, my lord? His statement. That was recorded on next day, my lord, on 12/6. Next day, his statement was recorded again by police, my lord. Next day, he said, statement of Asghar Ali, my lord, মোৰ নাম ঠিকনা ওপৰত কোৱা মতে সত্য হয়, মোৰ বয়স 50 বছৰ হয়, মই গাখীৰৰ ব্যৱসায় কৰোঁ, মোৰ ক'ব লগা এই যে যোৱা 11/6/22 ইংৰাজী তাৰিখৰ অনুমান 10-11 মান বজাত 1 নং পদকীয়াজনক দৈনিক তেওঁৰ ৰুমত গাখীৰ দিয়াৰ বাবে আহোঁ। উক্ত দিনা 1 নং পদকীয়াজনৰ ৰুমত গাখীৰ দিয়াৰ বাবে তেওঁৰ ৰুমত উপস্থিত হৈ তেওঁৰ ৰুমত কলিং বেল বজোৱাত 1 নং পদকীয়াজনে চিঞৰি চিঞৰি মোক মাতি ৰুমৰ ভিতৰত আহা বুলি কয়। মই সন্দেহ কৰি ভয় ভাৱ কৰি 1 নং পদকীয়াজনৰ ৰুমৰ ভিতৰত সোমাই গৈ দেখা পালোঁ যে চিলিং ফেনত ছোৱালীজনীয়ে চিপ লৈ থকা দেখা পাওঁ। লগে লগে মই 1 নং পদকীয়াজনৰ লগত চিপজুৰিৰ পৰা নমাই 1 নং পদকীয়াজনৰ লগত চিপজুৰিৰ পৰা নমাই ঘৰৰ বাৰান্দাত নমাই দিয়া হয়। মোৰ ক'ব লগা এই যে ছোৱালীজনী শাৰীৰিক অত্যাচাৰ কৰি that's his view. But the fact what he has stated on the first day, he said, my lord, he said, the eyewitness said, I have seen the girl was hanging, the person was holding him and holding her, and on the first day he said, I refused to help him. On the second day he said, I helped him, I unhanged him, I helped him, I unhanged the girl along with the boy, and we brought the girl to the veranda. That is in the second statement. And another statement, my lord, that was taken on 18/8/2022. That is months after the incident. That is, my lord, in fact, this case was, my lord, after the police, this case was handed over to CID. CID has taken this statement. Statement of Asghar Ali, my lord, witness Asghar Ali. মোৰ নাম ঠিকনা ওপৰত লিখা ধৰণে সত্য। মই কেঁচা চব্জি ব্যৱসায় কৰোঁ আৰু গৰুৰ গাখীৰ বিক্ৰী কৰোঁ। মোৰ দোকান ভোলা চকৰ সোণাৰী মাকৈত যোৱা 11/6/22 তাৰিখ শনিবাৰে ৰৈথাৰ পৰা কেঁচা চব্জি লৈ এছভেনত আনি মোৰ দোকানত নমাওঁ। তেতিয়া ৰাতিপুৱা প্ৰায় 8টা মান বাজিছিল। তাৰপিছত মই ঘৰত গৈ ৰাতিপুৱা 10 মান বজাত চাৰিঘৰলৈ গাখীৰ বটল আনি হীৰাপাৰা গাঁৱত থকা ৰূপম চাঁদ ওৰফে সুদীপ্ত চাহুৰ ঘৰত ভাড়া থকা ভাড়াতীয়াক গাখীৰ দিব যাওঁ। মোৰ ঘৰৰ পৰা তালৈকে চাইকেলেৰে 5 মিনিট মান লাগে। মই উক্ত কেম্পাছত সোমোৱাৰ পিছত ওপৰৰ মহলাত ভাড়া থকা দুঘৰ মানুহৰ তলতে পাই তেওঁলোকক তাত গাখীৰ দি দিওঁ। তাৰপিছত ওপৰৰ লাষ্ট ৰুমত থকা অসমীয়া মানুহঘৰক গাখীৰ দিবলৈ উঠি যাওঁ আৰু কলিং বেল টিপাত মাজৰ ৰুমৰ পৰা চিঞৰে, ঐ গাখীৰৱালা এইদিকে আহ। মই তেতিয়া ৰুমৰ দৰ্জাখন পৰা দেখোঁ যে সেই ভাড়াতীয়া পৰিয়ালৰ মতা মানুহজনে কাম কৰা ছোৱালীজনীক ফাঁচি লগা অৱস্থাত ডাইনিং টেবুলৰ পৰা ওপৰত দাঙি ধৰি আছে আৰু মোক ধৰি দিব কয়। মই দেখি ভয়তে নধৰো বুলি কওঁ। চিলিং ফেনত কাপোৰ এটা মূৰত বন্ধা আছিল আৰু আনটো মোৰ ছোৱালীজনীৰ ডিঙিত পেচ লগা আছিল, কিন্তু বন্ধা নাছিল। ডাইনিং টেবুলৰ ওপৰত অলপ চাইডত দুখন সৰু সৰু চাপৰ টুল এখনৰ ওপৰত আৰু এখন প্লাষ্টিক ৰখা আছিল। Well, later part there are some interrogation questions and answers. Malad, the basic point is, Malad, he has seen that the person was holding the girl while he was hanging on the ceiling. That was the only point what the Malad eyewitness said. In one case, Malad, he has himself contradicted in 2 occasions. Malad, in one case he said that I helped him. In one case he said I did not help him. That is the only contradiction. Otherwise, he has seen that the girl was hanged on the ceiling fan and the person was holding her, and he asked the help of the milkman to help. That was he is the only person who has seen the occurrence, none other. Others only, my lord, the circumstance, other facts, others witnesses are not eyewitness. He is the only eyewitness of the incident, man. The all others have seen only after the girl is brought out to the veranda after the incident. Thereafter, some people gathered. The incident has been, all persons has gathered. Police has come. Police has been informed. Police has come. Inquiry has taken place. So there are other witnesses who has seen the incidents only after the present circumstances. Now, my lord, the case is it's a big case, my lord. It's a huge voluminous record. Only 2 points I would like to read. First of all, the entire case is based on the, my lord, as I have already said, based on the, my lord, second autopsy report. The first autopsy report is in favor of me, and second autopsy report goes against me. It is said, my lord, the second autopsy report has said, but in the second autopsy report, they have relied on the first autopsy report, as well as the, my lord, the post-mortem done after 74 days of the exemption of, by exhuming the dead body. So in these circumstances, my lord, one thing we will have to mind, my lord, it's an opinion. It is an opinion, my lord, and it is settled position of law. Medical report, my lord, post-mortem report itself is not enough. It is not a substantive piece of evidence. It should be corroborated by, my lord, the circumstance evidence. Now, what circumstance they have, my lord? In the present case, another aspect, my lord, and second issue, my lord, while the person is was in detention, they have taken a blood sample from the person, and it was sent for, my lord, the DNA test. My lord, I have the prosecution story is that they have collected, my lord, the blood from the person, accused person, and they have some materials, my lord, in the scissors, and from the scissors there are some semen found in the scissor and semen and blood in the scissor article, and this is matching, my lord. That is matching. That is the second ground of, my lord, there, my lord, search sheet, filing of search sheet. So basically, these are the two grounds. And third is, my lord, the confessional statement, the alleged confessional statement, and leading to the recovery of the, my lord, weapons which was used for the purpose of murder. That was, surprisingly, that was not done in the present case. The leading to the recovery was not done in the present case, man. It was done in some other case, and that was seized later on in the instant case. Surprisingly, I don't know. The CID has not made the recovery. It is made by some other, in some other case. There the confessional statement was recorded. The disclosure statement, in fact, I will not say it is a disclosure statement. There is no disclosure at all. But they have said on the basis of disclosure statement, my lord, they have recovered the articles by which the girl was murdered, and that was sent for a second. Now, the circumstance, my lord, the FSL has clearly said, after the, my lord, FSL report has said, it is in the search sheet itself, my lord, there is nothing in the rope, the murder weapon, to show that that was used for the purpose of murder. That has gone. FSL has said there is nothing in the, my lord, it is there in the report. FSL has said, my lord, there is nothing in the rope that that was used for the purpose of, and no blood and X-ray is found. So that is negative. And, my lord, that is in document, my lord, if it is in document 60, my lord, document 60 was there, 60. Page 267 of the book. My lord, I am reading the report, my lord. This is by the Senior Scientific Officer, Director of Forensic Science. It is the description of the article, my lord. It is also in part 2, my lord. Just I am reading out, my lord. Probably, your lord, if it is possible, I will compile this, my lord. My lord, here the description of the article was, one coconut rope suspected to be contain stain of blood, total length of the rope 564 centimeter, marked as SLI. That's all. The result of the examination, it is said, exhibit so get negative result for presence of blood. So that is one aspect, my lord, that the weapon which is supposed, my lord, alleged to be used for the purpose of murder, that and as per them, my lord, it is recovered by on leading to the spot by the accused person. And that is, my lord, on the basis of disclosure statement. In fact, if your lordship go, I have the disclosure memo, disclosure statement. There is nothing such of disclosure where it can be said that it is a disclosure memo. And the Honorable Apex Court has laid down what should be the disclosure memo. The, my lord, report of the, my lord, FSL is page 267 of the search sheet, and part of the document 60, my lord. Part of the document number 60. So, first, yes, my lord, I will like, I'll compile it, my lord, only those parts which are necessary for the purpose. Otherwise, it's a big volume bunch. And second issue, my lord, while doing the post-mortem, the doctors, my lord, against whom they have alleged some, my lord, misconduct or misappropriation, my lord, the criminal guilty of offences, my lord, they have collected some documents, some articles, my lord. What I was suggesting, if it is probably in this part of the practice, my lord. Documents 29, B29, my lord. Documents 29. Results of the examination, my lord. Here it is said, what I was supposed to say, no evidence of sexual assault is found. No evidence of sexual assault is found. There is a finding in that report. Document B29. Result of the examinations, my lord. Number 1, negative for alcohol, drugs, psychotropic substances on the stomach. Number 2, negative for alcohol, drugs, psychotropic substances, liver and kidney. Negative for blood and semen. Positive for human blood and semen. Number 4, my lord. Number 5, negative for blood and semen on the other garments, my lord. No hair could be found on the garment. Then, my lord, the next part, from the findings of the medical legal autopsy, we are of the opinion that the cause of death is due to asphyxia as a result of antemortem hanging, which is suicidal in nature. No evidence of sexual assault is found. These are the doctors who have on the very first day, my lord, examined and given this report. Now they are challenging this. In fact, my lord, this later on, the sweep was taken, on the very day this rape was taken, there also the FSL also, it is confirmed there's no sexual assault is found on the body of the victim. So, primarily, my lord, from the sole eyewitness of the incident, it is clear that the girl was hanged, found in the hanged position, and it was hanged, brought down by the accused person. And whether he helped or not, that is contradicted by himself, but that is their evidence. They have brought him, they have taken his statement. And secondly, my lord, the leading to the recovery, on the basis of which it is doubted about, it is confirmed that the petitioner has caused the death of the victim girl. That has said there is nothing on that weapon which was used for the purpose of murder. And thirdly, it is clear from the FSL report, it is there in the FSL report as well as in the doctor's evidence, doctor's statement report, that there is no sexual assault on the victim. So all these things, break the scene of the circumstances, what the prosecution wanted. Prima facie, my lord, I am not arguing. There are lots of evidences, technical issues are there. I am not on those parts. Prima facie, as I have said, they have searched it, filed searched it on the basis of this only. One is second autopsy report. Second is that DNA report. Third is the leading to the recovery of the article which was used for the purpose of murder. Now, first, with regard to this post-mortem report, second post-mortem report, it contradicts the first post-mortem report. So, it cannot be accepted as a absolute piece of evidence or substantive piece of evidence, and it is settled position of law. The post-mortem report is not a substantive piece of evidence. And they themselves said, the police themselves said that it should be corroborated by the circumstances. Then only whatever they have given opinion, that may be correct. Secondly, the recovery. Secondly, the seizure of the alleged garments, whether seizure was correct or not, seizure was properly done or not, whether those seizures were actually of the victim or not. Because if I have seen in the report, the police report, it is said, as per them, these articles were seized by these three doctors. Those were given to one as a police. He brought those articles to police station. He has handed over to some other person, some other police. He has kept those articles in somewhere in police station. Then it was sent for FSL after almost 1 month. And the investigation authority has later on, with the permission of the learned court below, has taken blood from the petitioner and in the jail itself. But it is not known whether it was properly explained to him or not. But it was taken from him, and it was we as who have doubt there is some manipulation in the DNA. In fact, because the alleged seizures of those articles were not proper, because those were not properly seized. So that is second part. Third part is, as I have already said, the leading to the recovery. They have failed to prove, in fact, they have failed to bring any materials that leading to the recovery was proper, and that has some relevancy. That with the rope, coconut rope. As per them, it was used for the coconut rope. A coconut rope was used for the purpose of strangulation of the girl, and that was recovered by leading by the accused, the present petitioner. So there, they have failed to brought any materials to show yes, it was used for the purpose of murder, and exactly it was the rope which was used for the purpose. Because the FSL has said it is there is no blood, nothing, tissue, no tissue has been found in the my lord, from the rope which was seized. And the disclosure memo, it is not a disclosure memo. It's a statement. But statement doesn't mean disclosure memo has some qualification, my lord. It has to be stated in a proper manner. It is not, if I read out, my lord, it is, but those are technical points, I'm not on that. But it is clear, my lord, the FSL has said that rope was not used for the purpose. Now, what circumstance else remain, my lord? They have brought some other people who has shown the incident after the accident has occurred. No, he did not rush to the police station in a very harassed manner. Immediately after, their allegation is that why you did not go to police station immediately, or why you did not call doctor or police while he was in a hanging position. That was their allegation, and the people of the nearby people has said we asked him, but immediately after 5 to 10 minutes he went to the police station. He called, registered the case. In fact, before registering, he has called the police, registered the UD case, my lord, immediately thereafter. There is no delay. Delay maybe 5-10 minutes. In such situation, my lord, the wife was not there. The minor son was there along with him. My lord, the victim was, my lord, in fact, he was asking everyone to check the pulse because she was not died till death, my lord. Actually, he was trying to help the girl, but she collapsed. So, those are the circumstances the prosecution has brought, that he did not rush to police station in a very initial manner, or he did not rush to the Malad, he did not take the girl to the hospital for treatment immediately after the incident. Those are the corroborative evidence, the circumstances what my learned friend will probably argue. Now, my lord, the entire point is why the person is to be detained after 2 years, till 2 years. Now he is going to finish. By 30th of this month, he will complete 2 years in the custody. And as I have already said, my lord, submitted. The search sheet was filed long ago, my lord. Search sheet was filed on 25/9/2022, and since then, the SARS, we have argued on SARS, my lord, but SARS is not yet come. No, as a matter.
Charges were framed, my lord. Charges were framed against the present petitioner. Only against one petitioner, the charges could not be framed. The charges were framed, but in fact, the formal charges could not be read out because he took some certain exemptions after taking an High Court order. So he approached the trial court and said that I was personally exempted. So for this date, and on that pretext, he took so many dates. After a couple of months, the High Court dismissed the criminal division petition. Challenging that particular criminal division petition, he went to the Supreme Court. Only against one petition. Other total 5 accused persons are there in the case. Against him, the charges were framed long back 28/11/2022, and his his bail application doesn't reflect that he have annexed that particular charge order. The charge order is of 28/11/2020, and let him submit. I will submit my quote.
Then the SARS is framed, SARS is framed, but SARS in case of one accused has not been framed or read out, whatever my learned friend is saying. Probably it is written out, but it is not read out, so it is not formally framed. Now, for that purpose, the entire proceeding is, my lord, I have been there in custody since 2022, June 2022, and my lord, the charge sheet is filed on 25/9/2022. Who is suffering, my lord? If, my lord, my submission is, if the accused person is found guilty tomorrow, his 2 years has been gone. He has minor son. He has his wife. And he lost his service. He was in service. I am not saying that the petitioner will not, my lord, participate in the proceeding. But due to, my lord, there are numbers of witnesses. They have collected numbers of witnesses. There will be numbers of witnesses. And my submission is that, my lord, What is the purpose of detaining the person for more than 2 years? My lord, I admit, my lord, that the POCSO Act has said that the person, whoever, my lord, the presumption is against the petitioner, against the accused person. So, they, if the search sheet is filed or if the search sheet is not filed, then bail may not be granted in certain cases. But POCSO Act itself says the trial should be completed within 1 day after the cognizance. 2 years have passed away, 2 years have gone. No trial has not been started. How long it will take, it is not known. It is not my fault. I am always appearing after 14 days, madam. I am in custody. I am appearing the date, each and every date I am appearing. And it is not, my fault. There are accused, 2, 3, 4 more accused, my lord, they are in bail. 4 more accused are there. They are in bail. They were taken into custody, they were granted bail. 4 more persons, they are in bail, my lord. So they have no problem. But my case, my lord, I am suffering. I am in behind the bar for last 2 years. And so, our second thing, my lord, obviously I admit, my lord, the issue is there is a gravity in offense. The offense, as it is seen, it's a grievous offense, my lord. Obviously it is admitted position. But the other aspect of the matter may also be seen, my lord. First of all, my lord, 2 years he has been there detention. Secondly, my lord, the prima facie, this shows that the circumstances, it is not complete. Circumstances, there are break, my lord. Thirdly, there are break in the circumstances. There is only eyewitness who has only seen that the girl was hanging, the person was helping the girl. Only that was a statement of the person. And another aspect, my lord, the evidence so collected by the prosecutions are such in nature that it cannot be tempered or hampered by the petition. Because all these are based on the scientific evidence and evidence on record. These are documentary evidence. There is no sense of hampering the post-mortem report. Again, there is no sense of hampering the DNA report. There is no sense of hampering the other scientific reports which were brought into the record by the prosecution for the purpose of evidence. So there is no sense of hampering or tempering. Other evidences, my lord, most of the evidence witnesses are of the police, and there are police, and others, those who were resident of the nearby area, their statements are recorded under 164. Their statements are recorded under 164. So where is the sense of tempering or tempering the evidence which have been collected? So therefore, my submission is that, madam, for the interest of fair trial, because obviously, my lord, the only person, the wife and the minor son, is outside. The person who is in detention, who is immediately, my lord, arrested, in fact he surrendered himself immediately after the incident. He has every right to go for fair trial. But the delay of 2 years, even till then, no evidence, not a single evidence has been taken. In fact, SARS is not completed because SARS is still SARS against one person is left out. So, for no fault of the petitioner is behind the bar for last 2 years. Considering all these aspects, my lord, prima facie, in fact, there are evidence, my lord, there are contradictions, there are, my lord, low faults of the prosecutions, there are numbers of things are there, but apart from all those, my lord, prima facie, it is found that from this evidence, even though we accept that these are, my lord, evidence, the person, in a prima facie manner, person cannot be, my lord, convicted on the basis of such evidence. If he is not convicted, his 2 years of valuable life has gone. and it is not known how long it will take, because there are almost 70 witnesses are there. It will take another 5-6 years. If the Honorable Apex Court has passed any order, then it will take another more time. So in such circumstances, my prayer is that the petitioner, before your lordship, may be granted bail at this stage, and he will, no doubt, he will cooperate each and every day. He will appear, he will cooperate the entire proceeding. There is no issue, and there is no sense of absconding, because he has his small minor son, and his wife is working there in the office, and he is also a government servant. He has his permanent house and permanent residence in the Sonitpur district. So there is no such scope absconding itself. Otherwise, he could have absconded in a very first moment itself. He surrendered himself. It is not that police detected him and arrested him. He surrendered himself immediately after that incident. Then, from then onwards, he is in. And there is no, prior to this incident, there is no prior, incident or any kinds of allegations against the petitioner so far. So, in considering all this aspect, my humble submission is that your lordship may grant bail at this stage to the petitioner, giving any condition, I have some judgments, my lord. I am not troubling your lordship. Let my learned friend here.
May it please your lordship. The case as projected by my learned friend is of that it is a case of suicide. First of all, it is not a case of suicide. It is a case of cold-blooded murder. How it happened, let me explain, your lordship. The statement that has come on record and the statements which were there during the course of investigation amply says that this girl was killed when he was alive, and after that he was put in a hanging position, and no one has seen the girl in the suspended position. The statement of Asghar Ali, may I read your lordship the statement which my learned friend is relying upon. Statement of Asghar Ali. He is listed as LW03. My name and address stated above. I used to deliver milk to Krishna Kamal Borua at Dhula Bazar as usual. Today I came to deliver milk at his room. After ringing the doorbell, Krishna Kamal Borua, that is the accused, screamed for help from inside the room. I went to the room. I saw Krishna Kamal Borua holding their maid girl hanged from the ceiling fan and asked my help to unhang her. No one had seen. It is a clear statement. Holding their maid girl, he was holding the girl from below, and accordingly he is trying to untie her. What happened, my lord? The thing, he killed the girl, and it is the forensic evidence which has come on record that sexual assault has taken place. The charges have been put under aggravated sexual assault under section 9, punishable under section 10, which is not less than 3 years and extendable up to 7 years. Now, aggravated sexual assault was done. The forensic evidence says that there is a semen present in his torn undergarment. Now, that semen was, that torn underwear was sent to the FSL, and the FSL reported back that it was a case of human semen was detected. Now, the EDTA vials were taken for DNA profiling. Now, DNA profile has come on record. It is the profile is matching with the blood sample of the petitioner. So, this is a clear case. May I, Lord, take your lordship to that particular document, which I will not trouble your lordship much, but these particular documents have the relevance what I am saying. May I kindly pass it on. The first document is the report of the forensic evidence. That is the Directorate of Forensic Science has reported. It was probably numbered, if I have correctly remembered, C145-22. So that was, I have marked it with highlighter, and it was marked as the semen was detected in the underwear, and that was sent back again to the FSL for confirmation whether it matches with the DNA. Now, the DNA sample was taken during the course of investigation in order to ascertain the role of the accused person. Now, that has come on record as positive that this is no one else's semen, it was the semen of that particular accused. That is Krishna Kamal Borua, the present petitioner. Now, this is a crucial evidence in order to attract section 9P as well as section 10 of the POCSO Act. Now, this is the presumption under section 29 of the POCSO Act, which my learned friend has correctly said, but this was the initial presumption, which afterward it can be rebutted during the course of the trial after placing on record certain evidences. Now, this is the evidence of sexual assault. Now, let me come to the evidence of murder. Now, disclosure, he was talking about the disclosure memo. The disclosure memo was taken, it's true, the disclosure memo was prepared in some other case. But what is the requirement of disclosure as per section 27? One has to be in police custody. One has to voluntarily disclose. So he was at that point of time on 7/9/2022 when he disclosed that particular thing before a police officer, he was during the custody of that police officer. And he voluntarily confessed. And it is not that that particular case has no relevance in it. There are two cases. One case is of this UD case. There are three cases altogether, not two cases. I'm sorry. One, the UD case which got registered immediately after the incident, the police thinking that it's a case of suicide, as the accused tried to project it. And accordingly, police believed it and accordingly started the investigation. On the next day of the incident, that is, the incident happened on 11/6/2022. On 12/6/2022, the victim's father complained of murder as well as sexual harassment, sexual assault. And accordingly, the police started investigation, and it came afterwards before the SIT, which was formed by orders of the competent authority, and the CID investigated it. During the course of investigation, the actual picture of the accused person came into it, and accordingly, the evidences were relied upon in that manner. Now, the case of, so far as the witnesses are concerned, every witness has some role in this particular trial. Number one, the informant has said something about the recovery, about the allegations in the FIR. Asghar Ali, who is the milkman, he stated that I have not seen that particular person in the suspended position. One, if suicide has to happen, the girl has to be in the suspended position. He has to see the suspended portion of suspended position of that particular girl. He has not stated so. My learned friend is relying on that particular statement, which was first recorded. That is on 11/6/2022. The statement was recorded. He never stated that I had seen that particular girl, victim girl, in the hanging position. What he had seen, the girl was hanging with the accused person who was holding it from below. So he was supporting that particular stand. And during the course of investigation, it came to light, he killed the girl, and accordingly he suspended it from the ceiling fan. So that was the story of the prosecution. Now, what are the evidences which has come on record? That is the disclosure memo. I am talking about the disclosure memo, the requirement of section 27. The police custody is there, voluntary disclosure is there, and it was related to a particular case. And that case is not unrelated to this present case. Because as I have said, there are three cases. One is the UD case, which was got recorded immediately after this incident. The second case is the case which was lodged by the informant, that is the victim's father. And the third case is about the Child Prohibition Act. As the victim girl is a 13-year-old girl, and so one of the accused, along with this prime accused, was taken to custody in that particular case because it's a case of Child Prohibition Act, according to them. So these three cases were there. Now, two cases were amalgamated. Number one, that is the UD case, which was amalgamated, and the victim's father, which was lodged by the victim's father, that was amalgamated by an order of the court. Now, the evidences which are flowing from the record specifically says about the role of the accused person. So far as the recovery of the thing is concerned, the coir rope was recovered pursuant to his disclosure. And after the disclosure, the rope was recovered, and accordingly it was seized in that particular case. What the CID has done, it was re-seized from that particular case and brought it as a case property in this particular case. That is the Dhula PS case number 114/2022, which your lordship is presently entertaining. That is the Dhula PS case number 114/2022. So that case was, that rope was, though recovered in that particular case, it was brought on record in this particular case, Dhula PS, by way of a re-seizure. So this is taken place as per the established norms and practices, which is normally the police investigation, or normally in the police investigation, it is normally seen how they do. Without being a normal seizure in this particular case, I would have agreed that there is no seizure in this particular case. It was re-seized in this particular case, and I have that particular document, which I would like to rely upon. Just for your lordship's perusal and for ready reference, I am passing these two particular documents. These are the relied upon documents in the charge sheet, D35 and D42. The first, your lordship will find that we have re-seized it. Your lordship will find out that there is a disclosure memo of a particular date. So that is a re-seizure. Your lordship must have found there are out of several items, particulars of item number 5 or 4 in serial number. There is a disclosure memo. So this disclosure memo was taken on record in this particular case, in Dhula PS case number 114/22. The second, which I have given your lordship, probably it was document 42, D42. This is the disclosure memo, which my learned friend has told. He was discussing about how the relevance is not there in this particular case. It may happen, my lord, the coir was recovered, and after a long time, when it was recovered, forensic evidences in that particular coil, it may not be there because the skin tissues will be there in the hanging, the rope which normally uses, or the coil rope has to be sometimes surrounded by some human tissues. Due to lapse of time, due to certain environmental conditions, it may not be there. So we have, what the CID has done, the negative report has come, we have relied upon that negative report, nothing was there so far as the negative report, but it was the disclosure memo of the accused person, that is the bail petition. On the basis of this disclosure, the seizure was made and it was re-seized in our case. That is one part of the evidence. And second thing, the doctor's report. Now, my lord friend has strenuously argued on one point that this particular doctor's report, that is the second post-mortem report, which accepted the first post-mortem report, and in the sense they have gone to a certain extent in showing the culpability of the accused. Why I am saying so? Because the first post-mortem report, the way the first post-mortem report was done, and what they had recovered on the first post-mortem report, that was reflected. The viscera was sent, the undergarments were sent, the samples were sent, then the report came back to them that there are human semen in the torn undergarment. Even then, the doctors have reported that there is no sexual assault. Even then, the doctors have reported that there is no sexual assault. That is very crucial. Why the doctors, and the doctors, what my learned friend was referring, they are the accused number A2, A3 and A4. A2, the trial court has specifically framed the charge saying that they are in conspiracy with the prime accused. A2, A3 and A4 are the first post-mortem conducting doctors. And the second post-mortem doctors, we are bound to take the help of the second post-mortem doctors because we have to ascertain whether this particular aspect has been taken into consideration during the investigation or not. Because the question might arise that afterwards, what the second post-mortem report had taken, whether the second post-mortem was done or not. Because of that, we have exhumed the body on 25/8/2022. Immediately after 74 days, when we have taken over the investigation, the CID persons have taken out the exhumation process, and accordingly it was sent for the post-mortem examination. The inquest was done, second post-mortem was done. Now the second post-mortem reflects that what are the negligence that they have done in the first post-mortem report. It is relevant in the second post-mortem report. The second part, that in spite of knowing that there is a sexual assault which had taken place, because tracing semen in the undergarment itself speaks about there is a sexual assault which had taken place. Now the doctors had reported, very interestingly, no sexual assault was detected in the first post-mortem report. And that is the finding, not post-mortem report, that is the finding of the first three doctors, that is accused number A2, A3 and A4. They are the co-accused. And they were granted bail by the Honorable High Court at that stage because they were faced under only framing of improper report as per section 218 and 201. Of lesser offences, the High Court in its wisdom thought it proper and accordingly they were granted bail. I have nothing to say on that. But why the three doctors were made a party in this particular case as an accused, their role has been surfaced later on that they are in conspiracy with this prime accused, and in order to save the prime accused, they have done this type of activities. Now, the second post-mortem report goes on the record and says that the victim died during his lifetime, and accordingly he was hanged from that particular on that day. He was hanged in that position by the accused A1. It is not the doctor's report which I am saying, but the circumstances which speaks about that clearly says that not only the post-mortem report, not only the inquest report, not only the evidences on record, the oral evidence, everything, if your lordship will see as a gamut of evidence, the culpability of the accused comes out to attract the offences under section 302, 120B, 354A and 319B and 910 of the POCSO Act. So it's a very clear case of against the prime accused. So far as merits are concerned, enough materials are there. During the investigation stage, twice or thrice his bail petition got rejected. During the pre-cognizance stage and after cognizance stage, one bail petition was rejected by the trial court. Then again he moved before the High Court by way of this application. This is the, I think, fifth time which he had moved. So far as incarceration is concerned, for the 2 years, as he had said that the charge sheet was laid down on 25/9/2022, and still the trial is yet to be started. Now, as we know, the charges have been framed. The trial has already commenced only because of a particular difficulty related to accused number 5. He approached the High Court during this period when the charge framing process was going on at the trial court. He approached this Honorable High Court and by way of a criminal revision petition. And according to the criminal revision petition got dismissed. And he went to the Supreme Court. And that is why a little bit of delay is there. So far as this 2-year period, there is not much delay about this trial. And the offences which prescribes punishment of higher offences as 302 and other offences are there. It doesn't give that particular thing before in favor of the accused person to release him at this crucial stage of the trial. Trial has already started because the charges have been framed against him. Charges were read out, he pleaded guilty, he pleaded not guilty, and accordingly he claimed to be tried. So charges are framed. Only we are waiting for this particular thing. The next date is on 28th of this month when charges have to be read out to accused number 5, and soon after that we will be able to call summon witnesses as per the Honorable Court's order. So there is ample evidence on record. The gravity of the offence does not give a favourable position to the accused to seek bail at this stage. So my humble prayer before your Lordship is this: at this stage, when the oral evidence is there, because he is an SSB Jawan, there are say 5-6 witnesses are there of his unit who knows about certain facts and circumstances. I will not go into the details of this case because this will be entering too much on the merit. Because these witnesses will be able to speak certain crucial about the case. And if he is released on bail at this stage, he might tamper with the trial. Because there is ample chance of influencing those witnesses. Again, there are certain witnesses who are known to the accused number A2, A3 and A4, the doctors. They are from the same district. And accused wife also works in that particular 37 battalion of SSB. So, taking into consideration the entire aspect of the case, There is ample sense of influencing the witnesses. They are crucial. Your Lordship is very well aware about the POCSO trials. What happens in a POCSO trial? So, as a prosecuting officer, we know what happens in the POCSO trial. So, this is my humble submission before Honor. A victim girl of 13 years was shown as a person who committed the suicide. When he committed the cold-blooded murder, before the commission of the cold-blooded murder, he committed the sexual assault, and deliberately he laid a false story before the court, as well as till now he is trying with that particular aspect. Though it is his defense, obviously he will take, but only aspect is that at this stage, when crucial evidences has to be taken on record, before that, he can come up with a renewed prayer if there is a long delay, or your Lordship can also direct the trial court for expeditious hearing of the trial. And so far as the 1 year period which he was talking about in the POCSO Act, yes, that is there, but it was slightly in a different way, that the court shall make an endeavor. The court is making an endeavor. It is not that I am regularly attending that particular court. The court is regularly making an endeavor. Only the difficulty is that sometimes the Superior Court's order is on record and the court cannot go on to it. So we have to wait for this particular accused person to appear before the court so that the formal charge can be read out to him. This is the only difficulty. Otherwise, you would have called summoned the witnesses long back. So my humble prayer at this stage, when the trial is at a very crucial stage, when lot of witnesses, some witnesses, not lot of witnesses, out of 96 witnesses, not related to every accused is not related to him, but so that we can examine those witnesses in a very free, fair manner without getting influenced by anybody, whoever he or she is. So at this stage, my humble prayer before Lordship is to reject the bail and not to consider his prayer. So this is my humble submission. The records may be kindly taken note of what I have given. There is all legal evidences which the CID has placed on record. Only it has to become a conclusive evidence after getting it recorded in the trial. So we may be given an ample opportunity to produce those evidences in a very free, fair manner so that the witnesses doesn't get influenced at this crucial stage of the trial. It's a case of 13-year-old minor girl getting justice who died seeking some justice from every court. So this is my humble submission. Your Lordship make it kindly record it.
Well, at my submit, I have submitted already. Only one thing, madam. Obviously, the number of honorable apex court is numbers of occasions says, but the gravity of offence has to be seen in granting bail once it is searched, it is filed. But other aspects of the matter, as my learned friend already argued, the basis of the search is, as I have already said, only the second post-mortem report and the just for your convenience, I would like to read out the second post-mortem report once again, madam. Please put it. First part of the second post-mortem report, madam. They are heavily relying on the second post-mortem report. With regard to ligature marks, madam, it is in my petition, 103, madam. Page 103. With regard to ligature mark 4, madam. 103 page, madam. And the last. A ligature mark was described in the first autopsy report, which could not be elicited during the second autopsy due to advanced state of decomposition. But it is clear when the body was exhibited, it was in the decomposed position. And they are heavily relying on the second autopsy report, which was already decomposed. The doctors in this second autopsy report, they themselves say it is in decomposed. On dissociation of neck tissues, layer by layer, others they have described as the strip muscles right side neck and found to be chocolate brown in color. So they have admitted it was in a decomposed position. Well, then with regard to thorax, it is said extremely as described in the next page, 105, described externally as described. described, my lords, described by the, my lord, earlier doctors. In one case, my lord, they are relying the, my lord, the earlier doctors' statement of the one doctor. In one case, they are making them accused that they are in my lord, in conspiracy with the petitioner doing this act. They are taking this two stands, my lord. They are taking two stands. One is this: they are relying on the, my lord, the post-mortem report done by the first three doctors. Because in entire case, my lord, with regard to thorax, my lord, in number 2 also they have related as described, my lord, by the earlier doctors. And number 3, as described by the earlier doctors. This all they're all relying on the first post-mortem report. And then in lastly, my lord, as I have already, my lord, shown, at page 107, their basis is the first autopsy report. Based on the first autopsy report and findings of the second autopsy, that was due to compression of the neck during labor. So, how can they say, my lord, that I am in conspiracy with these doctors that's committed? So, my submission is, my lord, apart from this, as it is clear, I am not saying, my lord, DNA, I have doubt, my lord, the seizure, in fact, the doctors, my lord, as per them, my lord, doctors, these earlier doctors, they have seized these articles. The, my lord, my lord, panty, where the undergarments, from where they have recovered the semen. Those were seized by these doctors, earlier doctors. And those are accused now. Those are accused now in this case. And they are relying on their seizure. They are relying on their seizure. And they are made, my lord, accused in this case. What the prosecution want to say? Does they are relying on the seizure of those accused persons, or they are, my lord, doubting those accused persons? They did not do the work properly, or they did the work properly? So, my lord, technically, if I go, my lord, it is impossible on the part of the my lord, the prosecution to convict the petitioner, the my lord, accused person, on the basis of this evidence, whatever collected by him at the time of my lord investigation. Technical issues are there, my lord. If I cannot tomorrow, my lord, can they produce those 3 accused doctors before the doc for my cross-examination, whether they seized the articles properly or not? If the article is not properly seized, on what basis they can rely on those articles, my lord? That yes, the undergarments were seized by this person, these 3 doctors, and this, my lord, the semen which were found on those undergarments are matching with the blood of the, my lord, accused person. How can they say? So, opportunity to the petitioner should be given at that time. If I cannot cross-examine them, it will be defeated. The very purpose, the very act, the evidence of that, the seizure will not taken as proper evidence. So these are the technical issues. I am not going to technical issues. But prima facie, my lord, there are as my learned friend has said, the milkman has said, clearly said, the person was holding the girl, he was asking for help. I tried, in one case he said I helped, but in one case he said I did not help. The recovery, if I say, my lord, as my learned friend has said, that yes, under section 27 of the Evidence Act, my lord, it is necessary that he must be in custody and he must show the disclosure. What is disclosure memo? If I go to one by one, if I see the disclosure memo, where is the, my lord, description that this particular article is placed in this particular place, north, east, west, south, everything has to be there. Nothing is there in the disclosure memo. It can be, it is like a confessional statement given before the police, which is not admissible at all. This is not a disclosure memo. Disclosure memo has some particular, Supreme Court has clearly given the guidelines, what should be there in the disclosure memo. It should contain east, west, north, south, exactly in which position the particular article is there. That should be there in the disclosure memo. Where is there? Nothing of that kind, man. If your lordship see, I can read out the entire disclosure memo. It is there. Nothing says this. only statement is that, yes, I committed this offense, I did this, I did that one, and this article was used. That much only. Is it a disclosure memo? It is not a disclosure memo. It is a confessional statement given before the police. And it is not admissible in the court evidence. So, considering the entire aspect, my lord, and further considering the, my lord, the life and liberty, because Article 20 under Article 21 says, my lord, fair trial is a my lord, right given under Article 21. And my submission is that, my lord, 2 years have gone. When the, my lord, it is not known if Honorable Apex Court has passed an order, any order, it may again hang for another 1-2 years. That means the petitioner has to be there in custody until and unless for no fault. He is appearing it. He is not saying. And what, my lord, what are the, my lord, evidence, if as per whatever is evidence given by the, my lord, friend is saying, my lord, there are some SSBG ones whose statements are recorded. There is nothing in those their record statements. They have said, yes, he was there, he did not go to place. And these are not material at all. These are subsequent statements, subsequent incident. Yes, after the girl was brought down, he did not go to police station in time, and he did not go to the police, the doctor in time. Those are the only statement of those persons. Others are normal statement. Nothing is there. So how they will hamper, the petitioner will hamper. The entire evidence is the doctor's evidence, the expert's evidence, the scientific evidence. Those cannot be hampered and tempered by the petitioner. The recovery, leading to the recovery is done by the police. Those cannot be hampered by the petitioner. So at this stage, my submission is that, considering the length of detention, because he is for 2 years, and probably what my learned friend has said, 96 witnesses are there. It will take another 5-6 years. So the entire life of the petitioner will be destroyed if it is true. So considering the entire aspect, my humble prayer is that the petitioner may be granted bail at this under any condition, for lordship. That's humble prayer.
After vital witnesses are examined, they may come up with a renewed prayer. But only the thing is that we are concerned about certain witnesses which are very vital on record. I should not disclose right at this stage because that is the strategy of every prosecutor as well as the defense lawyer, not to disclose so many things in presence of each other. So I am not disclosing many things right at this stage. But only the thing is that what I will be examining them, what materials will be there on record, that is for the trial purpose. So far as the prima facie evidence is there, so far as the bail consideration for purpose of bail, there are enough materials seeing the severity of the crime, as well as the punishment and the length of detention, how many years he had suffered in comparison to the highest in comparison with the higher punishment which has been prescribed by law. That has to be taken on record, because unless and until that is considered, that will be a totally defeat of justice, because unless and until we place certain things on record in the trial court during his custodial period, it will be we are little bit apprehensive of the fact that it might get, some of the witnesses might get influenced. And what does witnesses, it cannot be divulged at this stage. But we are apprehensive of this fact. And it happens in the POCSO trial. What I am saying is absolutely truth, because it happens in the POCSO trial. I have seen in the state of Assam how the POCSO trials get overturned in the slightest mistake of the prosecution, as well as sometimes due to certain other circumstances, which I should not elaborate. This is the thing which is happening in the POCSO trial. So the time has come when the length of detention, I should not have prayed if he has, say for example, only 3 years of punishment and the 1.5 year he had already, he was detained in jail, then I would not have prayed, to be fair enough. But at this stage, seeing the severity of the crime, so far as 302 is concerned, and when the POCSO offences are being established, how it is established, I have placed the materials before your lordship. How your lordship will appreciate, it is the discussion of this honourable court. But at this stage, I am highly apprehensive, which normally happens in the POCSO trial. That is a maximum in case I have seen where the witnesses get influenced and they give a totally different statement. It happens. So I am a little bit apprehensive. So may I kindly at this stage, he should not be granted bail at this stage.
But yes, my lord, apprehension, only for the apprehension of the prosecution can the person be put behind the bar.
Based on the material.
No.
Based on the material. What I am
Apprehension is
saying.
not enough. My Lord, the Honorable Apex Court, I would like to read out this only 2-3 lines of the 2020, my Lord, 13 SCC, my Lord, 791. Only 2-3 lines of this. Because I'm saying, my Lord, I'm not saying the offense is not grievous. Offense is grievous. Gravity of offense is there. But other facts and circumstances, only on the apprehension, the person will be put behind the bar for 2-3 years, my Lord. That cannot be done. That is a violation of fundamental right under Article 21 of the Constitution of India. Constitution has given the fundamental right to person to live in liberty without the procedure of law. They cannot detain that, my Lord. What is the purpose of detention of a person, my Lord? What is the purpose of detaining a person? The Honorable Apex Court has relied on, my Lord, in this case, my Lord. This is 2020 13 SCC, my Lord, 791. Yes, it is said, my Lord, it is not necessary to refer decision which deals with the right of ordinary bail, because the right doesn't furnish an extract parallel to the right of anticipatory bail. That was in. It is nowhere interesting to that look back in 1924. It was held by the High Court of the Calcutta, so and so in year so and so, that object of bail is to secure the attendance of the accused at the trial. Well, attendance of the accused. That is the main purpose. Attendance of the accused. That the proper test to be applied in solution of the question whether bail bond should be granted or refused, and whether it is probable that the party will appear to take his trial, and that it is indispensable that the bail is not to be withheld as a punishment. So what my learned friend is saying, my Lord, they has apprehension. Only on the apprehension the person should not be detained. So I'm giving you.
What I am saying is that materials are there. I will say materials are there. And charges are being framed at this stage. So there is no question. And why I am not referring to so many evidences, because right at this stage when the charges are being framed, trial has commenced, marshalling of the evidence at this stage is not permissible. So as per the Supreme Court judgment, in so many catena of judgments it has been reflected that marshalling of the evidence is not permissible. So I am not reflecting without causing prejudice to the either side. So that is my submission. Otherwise I would have shown so many evidences that may prejudice the accused. The concept of fair trial starts from there. If I go on referring to the state evidences, I can take the whole day and I can state the whole evidences to place my arguments. But marshalling of the evidence at this stage, when the charge framing is there, when the trial court has already recorded it, when a similar criminal revision petition has already appreciated by the High Court and said that the marshalling of the evidence is not required at this stage. So these are the aspects which your Lordship may kindly take a note of. That is my humble prayer.
Otherwise,
if my Lord necessary, I may submit the compilation of 2-3 documents which where I rely on. I can submit. But tomorrow, today itself.
Oh, you have to apply it
Yes.
tomorrow.
Yes, by tomorrow 10:59.
Okay.
Only documents whatever I have relied on.
Otherwise, I think the case record is there.
Case
I don't
record
know
is
whether
there.
it is legible or not, but the scan copy of the LCR was called for.
Or-
And in the
or
earlier,
it's I mean,
I think it's a bulky one. And the most probably in the criminal revision, in the criminal revision petition 561, it was earlier your Lordship have said in another case, the 561, that scan copy was not so legible. So that is why your Lordship may kindly take note of it, that whether those copies were legible or not. Because
If
the
I'm-
scan
I'll-
copy,
I'll not furnish, madam, only 2-3 documents, madam.
In that case, if you're going to file tomorrow, then I'll not show it that it's both one. If it's not tomorrow, just file the document. I'm
Yes,
not going to hear the matter.
Okay.
It's
No,
already heard.
yes, yes.
And
Only for the purpose.
legible innocence is not the pagination are also not.
Pagination are not correct, madam. That's why I have got trouble in the entire case. So how? I will blame my learned friend only.
No, it is not my part. It is the duty of the court to supply and the copies.
Documents
So,
are
no way
not properly supplied.
Involved in that particular process.
Even if the paginations are not correct. What? Such a serious case, my lord, but the paginations are not correct. Nothing is properly recorded.
It is to Ayurveda.
Ayurveda. Investigation officer is his person, my lord. So you know.
Just pass on to your lordship those documents which I have already supplied. In addition to that, these are the certain documents which about your lordship can have a quick look of D14. That is the earlier document. Just I am referring to it. This is the reconstruction of with the help of Asghar Ali and all, because he is heavily relying on that milkman Asghar Ali. According to him, he is the sole witness who has who had seen the girl in the hanging position. But the record says that she was not in a hanging position. She was been lifted by the accused person. So the crime scene recreation was constructed with the help of Asghar Ali. That is D14 speaks about that. So that is why I am referring to it. And certain other documents which I had asked the IO to prepare it, and accordingly those documents were relied upon, as well as those documents which I have already supplied. This is related to the medical evidence. Yes, those are the medical evidences related to the DNA profiling, as well as the sample collection and the tracing of semen in the underwear. So those documents have to be relied upon from the first postmortem report, because those were given to us as per the first postmortem conducting doctors. Unless and until that, we cannot take that part into consideration which is not there. But which is there on the record, we have to rely on them. Because unless and until, because the starting point is from the doctors which have sent the samples to the, not sent the samples, they have handed over the samples to the one of the police personnel, and he handed over to the FSM. That is why we have to rely upon the first postmortem report. Otherwise, the first postmortem report has lot of contrary stand they have taken, which is reflected in the second postmortem report. That is my humble prayer.
I'll submit back tomorrow, 10:30. What?
Or he can submit by officially by today.
By today itself, by then, no problem. I can get it by 4:30. I will get it. Yes. Always.
Hello.
May I please, Your Lordship, my lord? It is a court-headed application, my lord, in connection with over case number AMT 14, my lord, under section 9, 31, 35, 6, 35, 8, 39 and 49B of the Wildlife Protection Act, my lord. I am on interim. On the last date the case diary was called for.
Case diary has already.
Lord, I have appeared before the IO, and my statement has already been recorded. And one of the main accused, that is the accused number 3 in the complaint case, my lord. My lord will file the complaint at page number 11. Noor Bahadur Magar, he has already been granted bail. So I pray that as is, then my lord, case diary may not be required, my lord. If my learned friend had obtained instruction, there is not even a single allegation against me in the entire complaint, my lord.
What is your name?
My name is Motion Hazare. It is against the accused number 1, 2 and 3 and 4. Motion Hazare. Not even a single allegation.
No, it's for both.
This is the
Five, so you're reflected as five.
Five.
What you not
My name is given, but not a single allegation in the complaint. If a lordship produces the entire complaint, not even a single allegation.
Lordship, it may be allowed, but some strict conditions, Lordship. The investigation should not be hampered, Lordship. If the IO wants him to appear, Lordship, that may.
I will appear, my lord, if the IO one directs.
Otherwise, Lordship may be allowed.
RB Guha, my lord.
Then under export undertake 9 31 6 8 56 8 that's 39 that's 49 feet of weather city for Mr. Gohan that but it's the not there's no protective strong. But most after obtaining the order of state, with one of captain and go still open and not Mr. Bot, not Mr. Bot, not for general for but that one that that I and is open is not about like but that go and that that but I it one
Hello, Lashmila.
May result. Lordship report had that thing is pronounced on earlier occasion. Injury report was called for.
In this case, my lord, CT was taken back, my lord, for producing the injury report, my lord. Let it come up next week, any date, my lord. I am saying for short date.
the injury report to WhatsApp and all.
Yes, because the receipt is there, that is why that is why sometimes they have to take it. Next, my lord, any day before the vacation, my lord, before vacation.
That is the problem.
That is that otherwise.
Anyway, fine. Monday when not possible. It will be on Wednesday. Wednesday. Next Wednesday.
Wednesday.
26. 26. But it's not.
I'm deeply obsessed. Deeply.
That is the Lordship. Lordship, this is an application for previous bail under 438.
Here the and FXL was also called for, I think.
Yes, sir. 37 also my similar prayer.
FXL, similar prayer, it is already taken back. CD. Over.
Lordship.
There also my otherwise necessary my they have not picked it.
FXL.
Not
No, otherwise CD is available or not?
it is my perhaps available but not before us now my record
It's not showing, but the 20.
Well, 20. But 23 and 37 is the same as far as
23 and 37. Out of same FIR?
Yes, as far as. Yes,
disposed of only.
Disposed of because considering is gangs of details
Yeah,
to my
only,
lord.
only.
But
Otherwise,
in this case, this is my lord 438 probably.
Yes, Lord.
These are the other examples.
This for one Sadiqul Islam. Another explain that it was done that
Sadiqul Islam is the FIR name, it was number 4 lord.
Huh?
Is the FIR name.
Sadiq and Jab.
Yes, sir.
In other case,
The police is searching them, lord. Police is searching them because on the day when incident he was also present, my lord. This person was apprehended along with the pistol, the other accused person they fled away.
so they are
The person who has been granted bail, lord, today, he was
not
caught.
only
Yes, yes. But this accused person they fled away.
Lordship, both the petitioners were actually plowing their fields and they are the owner of the tractors seized by the police. They are just mere cultivators.
Regarding material, Jiabur is not FIR name. Jiabur also FIR name. Both are FIR name.
but they are
The investigation is pending against them.
what do you think? Is it a good case for allowing them to be arrested or not?
The material is there, my lord, that they are, my lord, as per
That
the...
they are custody interrogation.
Yes, my lord. This is, my lord, one of the... This is one of the independent witnesses.
not at those materials are there. Now, as for some of the witnesses, they said the arms to them. So why? What what is the reason behind? Now, suppose generally what happens in a village area or something or area, etc. They require for land but generally they come with a lathi, doom or da, whatever. But they all are armed. That means they are armed. So where they got them? Whether they are connected with any or
No, no.
they may be, but how do you have any gun? I don't have any gun. So see, maybe it's a license or whatever. Don't. So how people can get armed like this or that?
Actually, only one arm, firearm was recovered.
That is from him, that who could be apprehended by police. Others, they have fled away. From independent witnesses, they catch those arms. From independent witnesses, that's it. That's all. One got apprehended by police or he got arrested, and then obviously from him, one was recovered. That has already been done for the evidence. The rest, they are all dead. It's not a case for They may not be involved, they may not be maybe or for them, or they may be that's why they have
Nothing there.
don't have any explanation. Have it. Why? But now they have to carry all the debris and pocket and all they carry those arms.
But they were already being threatened by their cousins. They were already being
That's why they carried all those arms. That if you
And they
threaten
fired
me,
also.
we will shoot you.
They fired also.
They fired and if you against me, we will shoot you. That's the position. Otherwise, how? Okay. We are hard. I'm hard. Over.
Logic.
And as they were right from that, from by they fired 4 rounds of 4 rounds. Your petition stands rejected.
May I please, Your Lordship?
Yes.
Lordship, straightway, Lordship will come to page number 33, last page, Lordship. Last page. Lordship, my whole family is facing trial, Lordship. Parents, my wife, me. NBW was issued against me, Lordship. Trial is going on before Special Judge Longia, Lordship. 2.5 years old case, Lordship. It was FIR dated 4/1/2022, Lordship.
What nature of case?
Lordship, NDPS, Lordship, some amount of psychotropic substance was recovered, Lordship. 52 grams with plastic container, Lordship.
Such is the case, my lord. My lord, whatever, my lord, in the searching, my lord, he has been shown absconder, my lord. Along with, my lord, 2 others, my lord. There are 4 accused persons, 1 was arrested, and other 3 they were shown as an absconder.
But later on they surrendered.
Now, my lord, searches submitted on 30/9/2022, my lord. Therefore, the court is issuing summon, lordship, they are not appearing, my lord. When summon is issued, lordship, they should appear, my lord. And this is an intermediate quantity, my lord.
So, Lordship, as per order 27
No,
to...
but here case for 33 page number. Accused persons Rajiv Ali, Rupina Begum, and Firuza. They were also shown as an absconder.
Absconder in the search, lordship.
Subsequently they appear, no?
They are on bail and they appear, Lordship.
They might have appeared, but these accused persons have not appeared, my lord.
I may be allowed to appear, Lordship, and next date is 1st of August, Lordship. And I will face the trial, Lordship. That much of permission.
The question is that, my lord, only, my lord, he may be appeared, trial court might rule it, my lord. Pass necessary order in accordance with law, my lord.
Otherwise, Lordship, if we go through the search sheet, Lordship, the search and seizure itself faulty, Lordship, defective. So I am not going into that part, Lordship.
That he will face at the time of trial, Lordship.
Definitely,
now,
Lordship.
He is facing, my lord, because he has been shown as an absconder, my lord. Now trial court is issued someone, he is not appearing, my lord. Now only, my lord, he may be allowed to appear, but trial court will pass necessary order when he will appear. No direct.
I will appear and face the trial, Lordship. 1st of August is the next date. So, Lordship, what I am making submission, Lordship, that if we go through the search sheet, Lordship, even FIR and other relevant documents, Lordship, that they have recovered 52 gram, Lordship, brown sugar, but Lordship, with container. They could not know where it is mentioned that what was the actual amount. So, Lordship, it itself is a faulty search and seizure, Lordship, and we know, Lordship, that defective search and seizure vitiates conviction, Lordship. So many plethora of judgments are there, Lordship. Judgmental orders are there. So, Lordship, we will face in the trial court. These things will be sorted out by the trial court. But at this stage, Lordship, I am seeking this, that I will appear on 1st of August, Lordship, before the trial court. That's my protection, Lordship.
From the order, Lordship, it is clear that from the day of receiving the certificate, Lordship, trial court issued summon, Lordship. Now, when trial court issued the NBW, then now he is appearing arrest.
But trial is pending for last 2.5 years. So now I will join the trial, Lordship.
Let him appear, Lordship. The NBW may be kept in evidence for 10 days, but trial court will pass necessary order, Lordship. This is my humble submission.
Why you have not surrendered or appeared?
Actually,
why you have don't? What was the reason you have not absconded?
When incident took place, I was in Chennai. Even at that moment also I was not there. Later on, till today, Lordship, I'm outside my locality, Lordship.
Fiber for it. Get that's pretty much
The next date is 1st of August, Lord.
Don't get it 1st of August. You are giving 10 days.
Lordship.
Till 10 days, your NBW will take available.
Lordship. Highly blessed, Lordship.
May I please, Your Lordship? My Lord, on the last occasion, my Lord, the learned petitioner sought time to go to the records, my Lord, in this case. And present petitioner, my Lord, he is the accused number 2, my Lord. And all the...
Who is if you have some, Mr. Borwa, you are signed.
My Lord.
You are dealing with the case.
Yes. I have gone to the case, came to be, my Lord.
Can is a case record.
Case record, my Lord.
My Lord, in this case, my Lord, present petitioner is the accused number 2, my Lord. And all the waiver tablets has been found in the house of the accused number 1, my Lord. I am the daily wage labor. On the date for my daily wage work, my Lord, I visited his home. Suddenly, police raided in this case and found this material, my Lord. And accordingly, I also, due to my presence found by the authority, and I am being arrested, my Lord. And therefore, my Lord, after arrest, my Lord, and another trial court, my Lord, after getting the forwarding report on 3/7/23, I am accused number 1 granted interim bail, and that is continued till finally, my Lord, on 12/1/2024, I have enacted order, my Lord. Since charge sheet has filed, my Lord, on that occasion, my interim period has been rejected, my Lord, and now I am before this honorable court, my Lord. Kindly have a look at the FIR at page 12, my Lord. from bottom paragraph, my lord. And in the charge of my lord, Nazrul Haq Laskar, accused number 1, my lord. Let's waiver tablets, my lord, 3000. Emma. Yes, 3,400 numbers contraband tablets, suspected table waiver tablets found in the house of the accused number 1, my lord. Then, my lord, forwarding report submitted, and accordingly, my lord, at page 18, annexure 3, my lord, I will directly take your lordship, page 26, the last rejection order, annexure 6. Accused persons are absent. However, learned counsel representing the accused person filed Hajira. Charge sheet has been received. The charge sheet shows the accused person Nazrul Haq, accused number 1, and a class of the impedent petitioner Milot are involved in the commercial quantity of suspected contraband heroin. Both the accused persons were allowed to on interim bail by order 3723 passed by the Honorable Session the Special Judge Kasa without perusing the city. In view of the above, since the charge sheet shows that commercial quantity of contraband, hence interim bail granted earlier is vacated and a petition for granting rejected. My humble submission in this case, due to my learned on occasion, last occasion, my learned friends so time for going to the records. If there is any material against me, so I am accused number 2, my lord. Admittedly, my lord, I am the daily lever. On the particular occasion, I went to the accused number house for my regular work, my lord. And I don't know, my lord, the accused number 1 already he is keeping that all materials, my lord. And I did just because of I am present there, I am being arrested, my lord. And if the material record, specifically any allegations against me, this is up to your lordship whether my bail can to consider or not. Otherwise, I will appear before the learned trial court and for a regular bail application, my lord.
So now, my lord, the question of materials available or not, it does not arise because it is such a case, lordship. And as per the Caesar list, lordship, this contraband recovered from both the accused persons, lordship. Their names are Nazrul Haq Laskar and my lord Akhlasuddin Laskar, that is the present petitioner, my lord. Now, lordship, they were granted interim bail, my lord, by the learned session judge. After filing of the charge sheet, lordship, their interim bail was rejected, my lord.
And all this material from the house of accused number 1, my lord, not my house, my lord.
And these are the commercial quantities, lordship.
Not my custody.
So I oppose this, my lord, bail application, but this is anticipatory bail, lordship. I
and
oppose this bail
this material from the house of accused number 1, not me, my lord. Then lordship.
I am, my lord, submitting on the basis of the materials on record, lordship. Because as far as Caesar list, lordship, it is seized from both the accused persons. And they have implicated one Abdul Kalam, from whom lordship, they have, my lord, they have procured the, my lord, contraband.
The other both the bail, interim bail granted earlier was rejected for both the
Yes,
both
both the
yes, my lord.
Now, what about the other accused? Is the trial? The other accused?
My lord, that is the order of 12/1/2024, my lord. And against the, my lord, accused number 3, Abdul Kalam, NBWA issued, my lord. They were on interim bail, my lord, because they were granted interim bail without considering the case diary, lord.
I am Akhlasuddin Laskar, my lord.
So, for this petitioner also interim was granted or not?
Granted, my lord. It was granted as per the order dated 12/1/2024, page 26, my lord.
And that order is also will find page
I guess
18.
I have seen.
And my order specified para 20.
Rejected subsequently.
Yes, my lord.
After filing of the charge.
After filing of the charge sheet, my lord.
And that thereafter they didn't surrender or.
No, my lord. After that, my lord, they have not appeared, my lord.
No NBW issued against me, my lord, and I will appear, my lord. Your lordship may give some time, 2 weeks, my lord. I will appear before the court and for bail appeal.
But interim was also rejected.
It was granted, my lord, without perusing the case diary. Well, I leave it to your lordship, my lord. Only my objection may be recorded, my lord. It's a commercial quantity, my lord. Commercial quantity. But they were not granted bail perusing the case diary, my lord. Without perusing the case diary, they were granted interim protection. That is reflected from the case, my lord, order, my lord.
case can come. Where was the if, would that by order it 12 months then it was and it was still paper but so that by code by that could be provided on as it was as it or as it was so that's why but they are not giving any
Milord?
comment on effective
Yes, Milord. Within 15 days, Milord.
maybe
Deeply obliged, Milord.
but no it
Yes, Milord. Milord, till appearance, Milord. Till appearance, Milord.
you appear. So they are not giving any time bound period since it is not there.
Yes, Milord.
So you appear put that 12 could be make the observation that earlier your perception was there in
Yes.
Yes, Milord.
Deeply obliged, Milord.
Yes, we have case demand. None of you. Yes, but in time production they are not appeared.
They have not appeared.
They have appeared. They are appeared. But
So after taking in that case you have to return back.
again return back the seat. Otherwise, there is we cannot list it also. The lordship has many cases are big.
That one picked up it in
No,
in
1
that
week.
case you have to
Again, then we have to regain if it is dead. 15/7. Let it be, my lord, in last week or last week of July, 29.
29.
Okay. Because it might not come because again after it can be only 20, 26.
26.
I have to shut up. With my seniors and leg you.
We have received the case very much.
Next week. Or after the vacation. Yes, sir. Next week. Motion day.
Otherwise, you are
Yes, sir.
that case again to have
They have, my lord, appeared before the IO, my lord, and it's been recorded, my lord, only, my lord. As far as the materials are concerned, Lord, there is a note of the investigating officer, my lord. Then that's like to say properly. Allegation of my lord making some spurious, my lord, liquor, my lord.
Yes.
They make the, my lord, original liquor along with some spurious brand, man. And they put the, my lord, original label in the liquor bottle.
But if where the police trade, that Godames will belong to me, but I have rented out to that one jail home. Anyway, Lord, my senior will appear.
My lord, let him appear, man. After vacation. Immediately after vacation. My lord, it is lying, my lord, from the month of May, Lord. Otherwise, Lord, may pick the next death month or death in the next week. But then after vacation. Retain the case there.
you retain it. You retain.
Retain it or we can return also, Lord. If Lord dies, then we can return it. Because it will be
And then if it's the matter of the last part of the month, then
to them. We'll return it and we'll again call for it.
Yes.
26 July.
Yes.
Month.
Interim medical. Right.
Before also, my lord, perhaps my lord, he also not appeared because he's the same council, my lord, as in 42.
What? The same contributor.
Yeah, my lord. The same order, my lord.
Here also they were on interim.
They are on interim.
What? But the difference is
Change it, my lord, 26.
Maybe we'll look at later next week on 25th.
25th also next week at Zonpur Prudel.
Possible. Whatever have received is there.
Skin copy Lordship.
Or any. Get the.
No. Skin copy is there.
But if that can cook is not even. Their page will be full. That's why. But if the can cook will come later on. You are showing as an F1, right?
F1.
After that.
Nice. Vacation ago tili all people. After vacation, any date lo. Before vacation, any date. 26. 26.
Immediately on
17, no.
7.
It's on 26, no. 26 zone lo, this month. Lo.
17.
What?
26 lo, this month is next week. Lo. 17 in July, the reopening report. Lo.
Immediately, if it is immediately by
Then
70,
70.
that is
If it is immediately after reopening, then 70.
But the next day, the trial court date is the in July 1st week. Lo. This is the problem.
18.
26.
May I please your Lordship? Lordship, this is a 438 bail application. The FIR is at page number 50. Lordship, the allegation against me is this, that while a police patrol party went to stop one gambling activity, I was, I along with some other persons have manhandled them. Lordship, otherwise, at page 15, Lordship, if I may read, with the subject and reference cited above, I have the honor to report that on 28/4/2024, I, along with the police personnel of North Lakhimpur Police Station, 1, Ajit Gogoi, 2, Amon Das, C3, Mintu Bailung, proceeded to Badhakpara village for an inquiry in connection with North Lakhimpur PS GD entry number so-and-so, dated so-and-so. Lordship, Lordship, my humble submission is this, Lordship, that I am being wrongly implicated in this case as an accused person. What has happened in this case is this, Lordship, I have never denied that I was not present in the place of occurrence. Lordship, I was present there, I went to see what was happening. Lordship, so therefore, I will pray for an interim relief because, Lordship, if I appear before the investigating officer, Lordship, I can explain, Lordship.
no.
Lordship, at least I can explain, Lordship, that what has happened.
No.
No, they are saying, Lordship, that my video appears, my face appears in the video. Lordship, it is there in the FIR. I can explain why my face is appearing before the in that video footage, Lordship.
But it is not reflected matter. Send the message.
This is the second time, Lordship.
Here, if the FIR says matter, mob also heard abuse that are on duty police personnel of South North Lakhimpur Police Station. The attackers are identified from the video, and his name is in the list of attackers.
That's why I'm saying, Lordship, if I can appear before the investigating officer, I can explain, Lordship.
No. Go back. 27 man.
I'm obliged, Lordship.
Mayor Page Lordship. Mayor Page Lordship. This is a 438 bail application, Lordship. A scan copy was called for. That was most probably received. In this case, Lordship, what happened? The present petitioner was shown as an absconder, but police has not followed the due procedure of law, Lordship. The section 41A was not complied in this case, Lordship. And if the 41,
Necessary for compliance of
41,
Why? Why?
because no notice was served against the accused person during the
In
investigation.
case of take what 41?
In every cases, 41 is required.
7.
My lord, I have perused the scan copy, lord. Lord, kindly peruse the 160% on the victim card, my lord. He has not directly implicated, but her, my lord, age is the factor, my lord. He is 17 years.
In such Lordship, I was shown as an absconder, and at this stage, the case is appearance stage. I will appear within 2 weeks, Lordship, before this court.
Let him appear, lordship, but trial court will, my lord, proceed in accordance with law.
After we can not for the other
No.
He is the only
accused person.
But only.
Only accused person.
My lord.
What?
It is in a scan copy, my lord. Attack prosecution.
Your name is?
Ranjit Das. Only he himself is okay.
You're on that or Rajit?
Ranjit Das, Lord. Item 47 is Raju Das.
Age is which contradictory.
Yes. I will be ready to appear, Lord, before the court.
What's your why you have why everybody don't accept contract? What's
No.
your ground?
The police, how can file charge sheet without, they have not visited my house, Lord. Only I know from the court that I was shown as an absconder. Therefore, I will appear before this court. Therefore, I first time filed this bail application before this court, Lord. No, not this, Lordship. 16.7 is for appearance. Someone is this. Obliged, Lordship.
Otherwise,
Yet not issued, Lordship. Only appearance test cases.
I have passed the order that no court
Obliged, Lordship.
I have seen your matter in the
My lord, can I pay to fix it on Friday, my lord? Because today time will not permit.
Friday, it's checking. Friday, I cannot say whether Friday will be. I can at least ask if the days to list this amount of meter because 30, 4, 5, 6, 7 meters, 10 meters are still there. So Friday, because these are very, it is possible after vacation. Because I have seen the guest record. Yesterday night I have seen your record.
My lord,
This is the record because it was a.
now the prayer is very, very.
I have seen.
Prayer is very small, my lord.
Prayer is very small for the video conferencing and all.
My lord. And my lord.
But you are appearing.
Actually, Central Government Council Mr. H. Gupta is appearing. So due to personal difficulty, he left the court just now.
H. Gupta is creating all the troubles, my lord. I am constrained to say, on the last occasion also he has antagonized me sufficiently. My lord, and I told the court, this is not the way. My lord, what sort of objection they will give? They have taken 3 days for filing objection. They did not file at all anything.
By the way, have you prepared the objection?
No,
Because I have seen they have already taken some time also for the objection. I have been filed by the other side.
No, sir.
It's a simple prayer only for video
No,
conferencing.
They are not going to be affected.
After vacation, we'll file the reply on objection in I.
Again, you are sick after vacation.
That's it, because 2 weeks are there, okay, then we'll get a.
My lord, I can tell your lordship, these are for just to taking time only, they will do nothing. And your lordship, kindly see how they are going to be affected. I am making a prayer, your lordship, if your lordship allows, the Delhi, my lord, they will see whether this prayer can be allowed or not. They may reject, they may allow. Just to give us refugee status. Now how they are going to be affected? My lord, India is not a party to the Geneva Convention 1951. That's the reason, my lord, the United Nations, they have taken a, my lord, they used to provide the refugee status to the parties. Now the position in the Myanmar is so critical. If I am sent back there, they will just kill us. We are from the ethnic minority committee of the Christian community, my lord. If I go there, we cannot survive. And that's the reason, my lord, last occasion I have given a circular also, what the authorities say. They should not be pushed back forcefully. Now this is the thing, we want a video conference to have a talk with that authority, whether they can give us that status or not. Now how they are going to be affected, or how the central government or state government is going to be prejudiced by it, and what sort of objection they will give. And if they were really sincere and serious, if they wanted to file any objection, they could have filed. Enough time was given. In the last occasion, although melody it was not written down, the Honorable Court has said, if you don't give any objection, we shall hear it without your objection. And they should not take the court for a ride.
In his presence,
otherwise I could have picked it on next week also, but most probably it may not reach or may not be possible because numbers of messages have been listed today also more than.
Yes, I am conscious of that.
Confident for you to have picked the date appropriately taken this 15 or 16. Reopening day 15. The 15 is reopening 15 on 16.
All right.
And definitely something will happen then. And to ask Mr. Gupta also.
Not chip, not.
So this is not the way to take adjournment.
Yes, sir.
If his objection is genuinely, we have to file the objection.
Yes, he will file.
Just file it.
Yes, sir.
Because otherwise, as they have submitted by Mr.
Yes, sir.
That
we'll do that.
there may not be any reason to
yes.
cause any prejudice to the
The message can be sent to Mr. Gupta.
Yes, sir.
If they don't file, without that, your lordship will hear it. Obliged.
Obliged.
Others to rest will be adjourned. I think that there are 4, 5, 6 numbers of bail matters were also there.
Let's come tomorrow.
Tomorrow I cannot. Tomorrow this is already out. We'll try our best to list the matters at bail hearing stage somehow on the next, but not tomorrow. Tomorrow or the day after tomorrow already that has been taken. So Thursday and Friday may not be possible. So next we'll try to accomplish those.
Much obliged.